My lord,
Yes.
interim order for input
Yes.
that matter was mentioned yesterday, my lord. Interim order expired on 13th September 2023. My lord. That is the case, my lord.
You're mentioning for extension of interim order. Give the number.
And my lord, kindly put this on. Make 14th, my lord, time.
Yes.
14 to ajke.
Make 15th.
It will appear as extension of interim order.
Supplementary list আছে supplementary list supplementary list আছে
My lord, may I be permitted to mention one new motion, my lord, for inclusion in the list? New motion, my lord.
Give the number.
My lord, may I be permitted to mention, my lord, item number? My lord, may I be permitted to mention item number 318 of your lordship's today's list, my lord? Urgency is that one motion, new motion. Urgency is that, my lord, the BLRO concerned, my lord, proceeded with the, my lord, mutation case in spite of the stay order passed by the trial judge. Learned suit is pending.
Will this court have jurisdiction at all?
My lord,
It's under the Land Reforms
my
Act.
lord, nature of the stay is that, my lord, not to change the character of this land status in respect of the, my lord, suit property, my lord.
It's appearing in the list.
Yes,
Please
yes,
wait.
318.
Yes, please wait for your turn. It will be taken up.
But next date is 3rd October, fixed by the BLRO, my lord. Now BLRO, my lord,
We
proceeded
have
with
the whole
it.
of September with us. Please wait for your turn.
Yes, yes.
Lord, extremely urgent motion. Lord, today at 11, Lord, West Bengal Small Industries Development Corporation is going to evict me. Lord, I tell you, Lordship, I am a lessee of the Beala Industrial Estate. Initially in 2013, they terminated my lease, issued an order of eviction. I challenged that in a writ petition. Justice Sanjeev Banerjee passed an order of stay of the eviction and the termination of lease till the disposal of the writ petition. Now the writ petition got dismissed, Lord, in the month of July this year. Now immediately after that, Lord, they again, Lord, started proceeding.
Perfect.
We
What is the
did not know
difficulty?
that. Now, Lord, day before yesterday, they served a notice that today at 11, they are going to evict us.
Yes, your writ petition has been dismissed on merits. What is that?
No,
They are-
not merit, dismissed for default, not merit.
You did not proceed.
Lord, I did, Lord, that's a mistake, but Lord, the matter is that the order was still disposal.
It is in the monthly list.
No, kindly allow me to move it, Lord, so that I
File
can,
and come back. No leave will be granted. File and
Lord, today at 11, they will
File
evict
will
me.
show me where today at 11 they'll
Yes. Eta din to didi.
Dekhi, Didi.
11, they issued the notice, we have received it, Lord, 12th evening. Kindly
All
see.
government work cannot be stalled by way of writ petitions.
Lord, my case is that they don't have the jurisdiction to evict me. That is why, Lord, an order till the disposal of the writ petition was passed in my favor. This is the order. Now, Lord, since the writ petition is dismissed for default, they cannot, Lord, take advantage of that.
When did you receive the notice?
This was received on 12th evening. 11th they issued it. 12th evening we received it.
Leave granted.
Lord, kindly allow me to move it today, Lord. I'll serve on them and come back. I am serving them an advance copy. Otherwise, Lord, it will become
They are
infructuous.
available, come back.
Lord, may I
You can
come?
serve them. I'll not hear
I'll
it at
serve
their
them. I'll
absence.
serve them through email, Lord.
Leave them.
Today at 2. I'm grateful to Lord.
Yes, yes.
No, but I'm not, at number 1, I'm with.
Oh, very.
item 1
I'm for the petitioner, my lord. I mentioned this matter for extension of interim order, but the affidavits are ready. Today I have served them, my lord. I should have served earlier. My lord, we are all there. My lord, there are a series of matters 1 to 5, I suppose. But interim order expires tomorrow.
Be extended for a limited period.
Yes. Till my lord 15th October. Or 6th, my lord, if your lordship kindly, my lord, subject to convenience. I am led by Mr. Shaktinath Mukherjee, learned senior advocate, my lord, in this matter. Why are you here?
Since it's a hearing matter, let it be extended till 30th November.
I'm deeply obliged.
But your lordship may kindly hear out the matter.
I'll
Yes,
take
yes,
the date.
yes,
side of the matter.
yes.
We can start this side of the vacation. Exception submitted on behalf of the petitioner is taken on record. Paragraph, the matter is ready for hearing. Paragraph, let the matter appear under the heading hearing on 16th
Yes.
October. That's the last week will be difficult. Very well, come back on 11th October, the week prior to that. 11th October. Paragraph, the interim order granted earlier is extended till 30th November or until further orders, comma, whichever is earlier.
Deeply obliged. My lord, same
But
order
I
may be
just
passed. in
only one prayer, if your lordship kindly, my lord, fixes this matter, because there are several hearing matters in lordship's list, my lord. My lord,
All matters are important.
my lord,
Vicky.
because,
Let it
my
appear.
lord, because
Let it
they are enjoying the interim order, so we
Yes,
wanted
let it
this.
appear. We have some time with us. Let it appear.
1 to 5 identical.
1 to 5 identical.
Want to add all identical matters.
এই নাম্বার অনুযায়ী ঢুকিয়ে দিন না ফাইলে।
The issue is identical.
All identical, all identical.
I'm extremely grateful, my lord. Deeply obliged.
Item 2 আমাকে access page
Item.
4.
4.
5.
5.
I'm appearing for the 5.
সব 11 তারিখ।
Item 6.
I beg to appear on behalf of the petitioner.
Yes, what is the application? This is a.
My lord.
Yes.
Last occasion, your lordship directed me whether the 1964 Act. Last occasion, your lordship was directed all the parties whether the 1964 Act will be dealt by Group 1
Well,
motion.
I find 1964 is applicable.
Yes,
Can be
yes,
dealt with by
yes.
this court.
Yes,
Yes.
my lord, in
Because there has been several change of classifications.
yes,
Like earlier, the 62 Act and 71 Act were under Group 9.
Yes.
Then classification changed. It has come under Group 1 now.
Now.
So this court is dealing with it. Similarly, this was maybe it was earlier under Group 9. So now it is no longer under Group 9.
When it has, my lord, so
These orders are passed long back. I've seen the orders.
Yeah,
I've gone through these
22.
orders.
I have some orders of coordinate bench where it is clearly mentioned that the 1964 Act dealt by Group 1, my lord.
I have checked.
now
Yes. I have checked and it is
another
a
one
fact.
oral instruction from my client that I may not appear in future in this matter. They have engaged some another advocate. So not kindly record my
Let me fix a date.
kindly
until
record
any
my
motion.
submission so that I can be exonerated. Otherwise, my lord, there should be some.
You will be automatically exonerated. You cannot make a future submission that you may not appear in future. If you do not
He has
appear,
already instructed me not to appear. Today itself. 8 and 11. Respond number 8 and 11. I record my submission there.
May I humbly submit one thing, my lord?
yes,
Lordship, last occasion,
May I take a lordship?
let the matter be fixed because learned counsel is not appearing.
one humble prayer, my lord, one humble prayer. Last occasion, your lordship, please to direct me whether the demand for justice was can be disposed of by this court or not. So, my lord, I have a order of my lord Justice Dipankar Dotto, my lord, where demand for
This
justice.
varies from court to court. I do not give a direction for disposal of demand of justice. You have to file a representation. I do not give that such directions.
I can't.
I do not give directions for disposal of demand of justice. You have to file an. Let me deal with the matter and let it be appear. Let it
My
appear
lord,
under
can it be,
heading motion.
one humble prayer, my lord, can it, the representation can be time
I'm
frame,
not dealing with the matter at all now, sir.
Hmm.
It was under the heading to be mentioned only to decide this issue. Let it appear because
Let it
learned counsel is not appearing. You are Mr. Bishash.
Yes, my lord.
one, my lord, I
Mr. Bishash.
tender my
learned
apology, my lord,
comma,
last
learned
occasion.
counsel for the. তার আগে করুন
Number 8 and 11.
it appears that matters pertaining to the West Bengal Highways Act 1964 falls under Group 1 of the classification list. Paragraph. Learned counsel for Mr. Bishash, learned counsel for respondent numbers 8 and 11 submits that he has been instructed to withdraw from this matter. Paragraph. Let the matter appear under the heading motion on, it's a short matter, isn't it?
Yes.
28th September.
20.
Deeply obliged.
Get me.
My lord, I tender my apology for last day's conduct, my lord.
Yes,
For last day's conduct, I tender my unconditional apology. Last days, I could not serve the other side, my lord.
oh, that's all.
So I really beg. Deeply apologize.
Next,
Item 7.
Item 7, I appear for this statement.
For the petitioner, my lord. My lord, on the previous occasion, my lord was pleased to direct service. My lord, I am not prepared
Yes.
with a formal affidavit of service, but I have served. My lord.
come back with the affidavit, sir. I'll
My
give
lord,
you some more time.
My lord, as such, they are appearing.
My lord, I
no
have a
private
serious
correspondence.
objection to this application, my
What
lord.
is the
Five
application about?
five applications are there, my lord. One is for restoration, two section 5 application, and two
There are private
applications
respondents.
for setting
No,
aside
my
the
lord,
abatement of this writ. My lord, this is a matter relating to, my lord, Kolyani property. 1963 land was allotted to them. And thereafter, till 53 years, they did nothing. Thereafter, the
You are on
department.
merits of the writ petition, sir.
Yes.
You are
yes.
on, please
And
submit on the merits of the
not only
application.
that, 2016, the land was taken back. And 2018, after 2 years, they have filed the writ application. After filing the writ application, they kept silent, my lord. In the year 2023, the matter came up before the Honorable High Court, and the Honorable High Court find no one my lord, arguing on behalf of the petitioner, so matter was dismissed. And the person concerned, those who filed the writ application, they died in the year 2020, and they have come up now.
That's why there's a prayer for abatement. Do you want to use the affidavit against this? Or you want to fight it out in the main writ petition? Your choice.
I shall file affidavit.
Affidavit,
Yes.
very well. Because you know that all the courts are very lenient in considering these applications. And the submission that you have made is on merits of the writ petition. So you can make your submission on merits of the writ petition only when the writ petition is restored, not before that. So if you still want to use affidavits, please come back.
My lord, there were 2 deaths in the family in quick succession, my lord. And also, my lord, the erstwhile advocate became seriously ill and she has left the brief. And this is the reason for the delay, my lord.
You have
I will be-
explained it in your applications.
My lord.
5
I-
applications.
5 applications.
Please
my
come
lord,
back
are
if you want to use an affidavit. Learned counsel for the respondents seeks to use affidavits in opposition in the applications. It application gulo order have na? Can 1 থেকে can 5. Paragraph. Affidavit in opposition be filed within 2 weeks. Within 2 weeks from date. Paragraph affidavit in reply, comma, if any comma be filed within a week thereafter. Paragraph, let the matter appear in the monthly list of November 2023.
Unwritten sheet.
Item 8.
This is my contempt application.
Lord, I appear for the
Matter was
alleged
filed by
contempt.
your lordship 2 weeks back. The Learned Advocate General address on behalf of the contemptor, my lord. Review dismissed, your lordship will remember. It was to be considered favorably. Your lordship gave them 2 weeks time. After conclusion of argument, 2 weeks time.
Siddiqui,
Appeal was
My lord,
preferred,
we
appeal they
submitted-
sought for time.
We submit, no, my lord, they prayed for, my lord, filing of the affidavits before the honorable division bench, my lord.
before the appellate forum.
Before the appellate court, my lord.
The appeal they sought for time.
In our application under section 5, my lord, they prayed for time. The honorable,
No, we have
the
not prayed
honorable
for time.
division bench only granted them 1 week's time. We have been granted a 1 week's time to file the reply, and the matter has been directed to be posted after a fortnight, my lord.
Let it wait.
But kindly,
Can't help.
kindly.
But no, kindly record not the
You wanted
prayer
to
for
file
adjournment was made from the side of the state.
You wanted to file affidavit in opposition against the application.
They sought for time. Then the court said, I am adjourning the matter on their prayer.
the
If you
parties
want.
But I sought for a day's time because Learned Advocate General was indisposed. But even today is indisposed. So they said
Well,
he's not well. He's not well since Tuesday. He's not coming to the court. So, my lord, I sought for times only for a day's time. If the Advocate General would not have come, then I would have addressed the honorable court. My lord, then my lord, the
since
case.
both the parties are appearing before the
Fine,
appellate forum.
I'll-
and
I'll-
it's-
I'll-
Kindly take up after some.
Let there be
My lord,
some, yes.
I'm in contempt, my lord, no doubt about that.
After
But
vacation. Appeal has to be
No,
considered.
Kindly take up.
Appeal has to be
Kindly
considered.
give 1 date before the vacation, will not after the vacation. In the month of October, any date, in the meantime, the appeal.
On prayer of the alleged contemner, the matter is adjourned. Paragraph, it is submitted on behalf of both the parties that an appeal preferred against the order under contempt is pending, and affidavit in opposition to the application for condonation of delay in filing the appeal has been directed to be filed before the appellate forum. Paragraph, let the matter, in view of the above, let the matter appear under the same hearing in the matter list of November 2023.
I'm grateful. Extremely
October is not possible. After
Or
4 weeks, not possibly within 4 weeks, matter appeal shall be heard.
Liberty to mention.
No,
Mention if
can
it is
I-
completed before that, I'll consider.
Much obliged.
Liberty to mention.
Smile.
grateful.
যেটা আছে থাকবে। হ্যাঁ, liberty
If
to
it is
mention.
completed, leave it. Much obliged.
This one will be very busy during this last week of the vacation. So.
9,
Appearing for the petitioner, my lord.
Appearing for the,
Technically, I complied my part. In spite of that, my activity, I write evidence part compliance of law. My lord, if your lordship will see the order.
yes.
My lord, your lordship will, my lord, see the order. That is page second. That is my lord, 27, page number 27. My evidence, my
So I
lord,
can see the order, yes.
direction upon the respondent number 6 to assess the current market value of the land in question under the provision of the right to fair, competition and transparency in land acquisition, rehabilitation, resettlement, and pay adequate competition. That portion, my lord, I have the objection. As because, my lord, money will be paid by the requiring body. And for that is, my lord, I have completed my part. But now, my lord, if your lordship will come,
So you have assessed the
my lord, if
compensation
your
amount.
lordship will come to my part, my lord, that is the paragraph 10, my lord. Paragraph 10, page 4, my lord.
Yes.
In pursuance of the solemn order of the Honorable High Court, Calcutta, state report, rate report and estimated cost of the compensation is hereby prepared by observing the provision of the Right to Fair Act, and same has been calculated as 4,62,005 rupees. This rate report and estimated cost compensation approved by the district magistrate Bankura, that as the requiring body is the executive engineer, Vishnupur division, will pay the above amount to the writ petition. As
Is
per
the-
provision of law, at such ADM Bakura issue notice to the executive engineer
Yes,
for
yes.
providing necessary fund, my lord.
So is the requiring body a respondent in the writ petition?
Executive engineer, my lord, sir. Requiring body.
He's, that is respondent number 7.
Yes, my lord.
So I cannot give a direction. I'll just record that it is expected that it will be done within a certain period of
Yes,
time.
ma'am.
My lord, and I need an opportunity to counter this affidavit because, my lord, I just got it right now. The
Oh, you have been served
calculation,
just now?
I
Yes.
just now have been
Yes, my
served, just now. So the calculation, my lord, I need to check. Prima facie, my lord, I think it is not
If
correct.
you are aggrieved by the calculation, that is a separate cause of action. That cannot be dealt with in a contempt application,
Yes.
right? Contempt application has a very limited scope.
Yes. my
It
lord,
is
that
only to
is-
see whether the order is being complied with.
But this
Calculation,
is
that is of
again, my lord,
ethics.
yes, about on, but my lord, this is only a part compliance. So far as the
Yes,
initial
so
order
I
was there,
propose to, because the alleged contemptor has done his part. Yes, because requiring body has to place funds. Application has been made to the requiring body for funds. So that part is complete. Now the executive engineer has to place funds. So you can come back with an exception if you want to. Otherwise, I propose to pass an order with an expectation upon the 7th respondent, since he is not the alleged contemptor. I cannot give a direction. I can record that it is expected that the 7th respondent shall place funds within a particular period of
so in
time.
that case, my lord, if my lord kindly gives me an opportunity to file an exception if required on the, and a
Great.
short
Go
date
through this,
is.
please, and come back, right? Affidavit of part compliance submitted on behalf of the alleged contemptor is taken on record. Paragraph. Learned counsel for the alleged contemner submits that in compliance with the order of this court, estimated rate report and estimated cost of compensation has been prepared by observing the provisions of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act, 2013, at rupees 4,62,005. The rate report and estimated cost of compensation has been approved by the District Magistrate Bankura, and the Additional District Magistrate Bankura has issued a letter to the requiring body, being the executive engineer, within bracket 7th respondent in the writ petition, bracket closed, on 24th August 2023 for placing funds, for providing necessary fund, for providing necessary fund for disbursal of the same to the applicant petitioner. Paragraph. Learned counsel for the applicant petitioner seeks to use an exception to the report, if required. Paragraph. Let the matter appear under the same heading on 3rd October.
My lord.
Please serve an advance copy.
Yes, yes, absolutely.
Next.
ten,
10.
I'm for the
This matter,
petition.
my lord, I am, yes. My lord, in this matter, I have already filed.
There was a, on the last occasion, if I recollect correctly, my lord, there was a direction that they will give an opportunity of hearing, since it was a summer month, my lord, when the hearing was scheduled, my lord, and my petitioner could not arrive on time. So a direction was given, my lord, if a hearing could be provided to him, at least, I mean, even on a virtual mode, so that he will be satisfied that his.
Yes, there was an order on the earlier date, Mr. Dev. On 17th August 2023.
Yes, ma'am.
That was not that. Pocket hacking.
Yeah.
Pocket hacking. Then, my lord, give me another date, my lord, I must.
I'll give you a month's time. Please comply
Yes,
with
my
the
lord.
order.
Yes, my lord.
A final order was passed without hearing the
Yes,
applicant.
my lord.
So there's a direction for revisiting the issue.
Only one thing, my lord, if direction can be given that the hearing can be concluded by September. By
By
September,
the
by
next
them.
date, I'm calling for an affidavit of compliance. Yes. Learned counsel for the alleged contemner seeks accommodation to comply with the order under contempt in terms of the direction of this court in the order passed on 17th August 2023. Paragraph. Let the matter appear under the same heading on 6th October.
My lord, if it can be 5th,
Very well. 5th October.
deeply obliged.
item 11,
May I please, Your Honor? In this matter, I am appearing on behalf of the applicant, my Lord.
Is it appearing for the first time?
No, my lord.
So, oh, Mr. Day is appeared. Yes.
My lord,
My lord, only part is there, my lord, as because.
my lord, may I submit?
Put that. My lord, in this matter, my lord, your lordship was pleased to direct my client to file so cause. I filed the so cause, my lord, I'll give you the copy. So cause. My lord, in this matter, my lord, his address is not Salboni. For that reason, my lord. If your
The
lordship
contemporary
will
is
see-
present in court today?
Yes, my lord. Yes, sir.
Very well. Has the order been complied with?
My lord, compliant, only this portion is not compliant. That is the giving opportunity of being now. All the, my lord, if your lordship will see the so-called, all the part is completed, my lord. Only without giving him any notice, that was done, my lord. So already, my lord, yesterday, my lord, he will give the notice to the petitioner and that part will be completed within certain time. I pray some time to file compliance. My lord, in this matter, my lord, I have stated all the facts.
My lord, may I submit something? My lord, may I something, my lord, may I submit that nothing was complied? Right, my lord, kindly come to the page 32 of the your lordship's order in contempt application.
Yes, tell me.
Your lordship has been pleased to direct the contemptor to
Consider the representation.
consider the representation within a month, my lord. My lord, this was the order on 28th February. Now we are in September. And my lord, kindly consider their affidavit of compliance. They measure the land without informing us. They encroach our land. They admitted it without informing us, without giving us any notice. They measure it.
You heard the submission made by Mr. De.
My lord, they already measured and they admitted in the affidavit.
I repeat, have you heard the submission made by Mr. De?
Yes, yes.
So they will serve further notice upon you. That is Mr. De's submission.
My lord, kindly.
And everything will be done in your presence.
My lord, yes.
Sir,
My lord, kindly consider, may I submit one thing? My lord, kindly consider, we are the poor marginal farmer. Our land was encroached by the government without due process of law. Last 1 year, we are suffering. After filing, after order of this honorable court, they are not doing anything. They are just, we do not, my lord, kindly. My learned friend is too much senior to us.
The address of the respondent, he did not know address of the respondent. For that reason, my lord, he always write in the salmoni. And for that reason, my lord, High Court's notice is also not served.
But
and now, my lord, previous notice was not served, and last notice was served to the my lord contemptor on 31st. I have, my lord, given all the things, my lord. That is the act and action of the my learned friend, my lord. My lord, very good person. For that reason, he write one salmoni.
Yes,
not to serve the copy to the.
My lord, we also communicate the order of this writ petition to the Mindapur. My lord, the officer where he is sitting now, this is not our duty.
Please request the.
My lord, kindly see their compliance report.
You are aware that when the court speaks, you are not supposed to speak.
Sorry.
Please instruct your clients to hold the demarcation also in presence of the petitioners. That has not been done in presence of the petitioners. The entire exercise should be in presence of the petitioners upon service of notice to them.
My lord, within a certain.
The alleged contemptor is present in court and submits affidavit of show cause, which is taken on record. Paragraph. Learned counsel for the alleged contemptor seeks accommodation to comply with the order under contempt in its entirety. Paragraph, let the matter appear under the same heading on 9th October.
Yes.
Paragraph, personal appearance of the alleged contemptor is dispensed with for the time being.
Deeply obliged.
Next matter.
Deeply obliged.
I'm the petitioner, my lord. In this matter,
Have you
the
served? Yes.
contemptor has already complied the order, which has they have filed affidavit of compliance.
Already complied?
Already complied with, my lord.
Yes, my lord, I have already
Complied with.
It appears from the affidavit of compliance submitted on behalf of the alleged contemptor and is also submitted by learned counsel for the applicants / petitioners that the order under contempt has been complied with. Paragraph, in view of the above, the contempt application being CPN such and such is disposed of. Paragraph, there shall however be no orders to costs as is certified with set off. Next.
I am appearing for the petition. 30. I'm to respond. Your lordship's order is. Your lordship's order is at page 23.
Yes, has it been complied with?
My lord, the thing is that, my lord, in compliance of your lordship's order, my lord, we had given several notices to the petitioner, asking him for the documents and also to show us which is the portion, the demarcation where he wants the police assistance, my lord. But all the documents are on record. I have brought it, my lord. Your lordship is kindly pleased to, my lord. I have my lord, marked it with flags. May I hand over this copy, my lord? Lord will kindly take from huh? Yeah, just on a few instructions. My lord,
We served a copy to the.
my lord, this is in the my lord, this is since not in the form of affidavit or anything, my lord. It's my lord, in the form of my lord instructions. But my lord, since it's bunched up, my lord, I handed over, my lord. It'll be easier to show the documents. My lord will kindly take from my lord. My lord, the issue is with regard to 557, plot number 557. Kindly take page 5 onward, my lord. Page 5.
Yes.
4, 5, 6, 7, 8 line onwards after passing. After passing of the said order in connection with the said writ petition on 11 June 2023, the petitioner filed an application before the OC Mothabari PS for rendering police assistance in respect of Gangapot Islampur RS 557. Thereafter, on 19th of June 23, this contemner submitted an application to the Additional District Magistrate Malda with a copy of to District Magistrate Malda, Director of Fisheries Malda, so and so, and BDO Kaliachok, wherein it is categorically stated that during preparation of police assistance and render police assistance to the Mothabari Dhibor Samobaya Shomiti as per the order of the Honorable Court in connection with so and so, it has come to the knowledge that an announcement was made through loudspeaker on 16 March 23 that the water body leased property have been opened for all for fishing and nobody was required to pay any duty and seek clarification of the said announcement and putting some questions in the said letter and prayed for depute one competent officer to demarcate the area as reflected in the order of the Honorable High Court at Calcutta to render police assistance to Mothabari Dhibor Samobaya Shomiti as soon as possible. Now, that letter I have annexed. This contemner also received a letter dated 21st June 23 issued to the Superintendent of Police Malda for rendering police assistance. The contemner also issued letter to manager, that is manager of the petitioner, on 26 June 23 that police will provide assistance to you for fishing on 27 June 23 at 9 AM. And also the contemner issued mail to the Kaliachok 2 block and assistant director Fishery Malda for cooperation on 27th of June 23 morning, an announcement for complying with the order of the Honorable High Court. This contemner also issued mail to the SDO Shodor Malda requesting him to depute one executive magistrate at Mothabari PS on 27 June 23 for giving possession of so and so 557 RS to Mothabari Dhibor Samobaya Shomiti. The contemner also issued a letter to BLRO Block 2 for Block 2 for deputing one competent officer to demarcate the lease area of Gangapot Islampur 557. Thereafter, the BLRO Kaliachok issued a letter vide memo number so and so dated 30th June 23 to this contemner stating that the lessee of the said Jolkor could not submit any lease agreement or any other document mentioning the land schedule, and as such, the proposed demarcation could not be completed. I will kindly see this letter. It is marked as G. The flagging is G, my lord. But this is by the BLRO to the officer in charge. It says that report on demarcation of Gangapot Islampur 557. In reference to the above, the inquiry report of the concerned revenue inspector is hereby sending for information. It may be noted that as the lessee of the said Jolkor could not submit any lease agreement or any other document mentioning the land schedule So the proposed demarcation could not be completed. My lord, there are host of other letters also, my lord, which I can place, but the difficulty is that the petitioner himself is not being able to demarcate where he wants the police assistance. My lord, the lease of the petitioner continues, my lord, from Manik Chowk, then a part of English Bazaar, then my lord Mothabadi, then whose report this is, my lord, then of Kaliya Chowk, then of Vaishnav Nagar, and then of Farakka. Now, my lord, from two officers, my lord, I have got the instructions. One is of Mothabadi and one is of Manik Chowk. But the petitioner, my lord, has to demarcate in which portion he wants the police assistance. Because this is, my lord, covering 1, 2, 3, 4, 5, 6 areas. So, my lord, the petitioner repeatedly, my lord, there are several other letters, my lord, I can show. The petitioner was also informed, petitioner manager was also present at various times, but they are not being able to demarcate where they want the police assistance.
Yes, let's hear the
Respectful
petitioner.
submission is this, my lord. It comes from my learned friend that the BLRO is, my lord, sitting appeal over your lordship's order, because like kindly see the letter what he has written. Your lordships, it is clear from his order, the lease was executed by the government. Government don't know what was portion he has given lease. The order is what the problem arises. Kindly see your lordship's order after issuing the notice by the district magistrate. The entire is open for catching fees. Then problem arises. Therefore, my lord, entire lease whole property is to be protected by the police. I have given the all 3 police stations that order to be complied with. My lord, they have not given any assistance. Now they said, I shall demarcate the land. Is it possible?
Have you pointed out the area? Because
Yes,
the
it is
direction is
in
upon
the,
the
it
police
is,
authorities, not the lessor. Yes, the police authorities are not supposed to know your portion.
yes, police
Have
authority
you
in which
demarcated,
area?
have you demarcated your portion to them?
Yes, I have given that particular OC Muthavari. In which
You have given a copy of this order. Have you given the demarcation?
demarcation, my lord, it is part of that 3 blocks. 1 blocks coming under Mothabari police station.
Under police, by way of police assistance, you cannot cross the area given to you by way of police.
Absolutely, absolutely. Therefore, the area which they have given, that should be protected by police.
Who is this they?
They mean state
Because
government.
the direction is not on the state government, direction is on the police authorities.
Yes, but
Who
the
are not supposed to know the area. Why
But-
don't you provide them with the area?
Area was already mentioned.
in that area, my lord.
Have you
kindly
given
try-
them a copy of your lease deed to show the area?
Yes, my lord,
Where is
kindly,
the
kindly,
document?
kindly see the letter and writ petition which was served upon the police authority.
এটাকে contempt. এই যে writ petition.
That writ petition was served upon all the police.
Not the writ petition, sir.
I
along with-
know, your lordship, they have taken stand that the location where the police will give assistance, that has not been determined. They have wrote the letter to the BLRO. They have wrote the letter to the additional district
Who is
magistrate.
the alleged contender in your contempt application?
ওসি মোতাবাড়ি এসে
OC Mothabari, my lord, kindly see that contemner.
OC Mothabadi, OC Manik Chowk, additional superintendent of police, and block development officer.
Officer. They, my lord, they are the parties because they will give render assistance within that area. The entire my
The
leasehold is
direction is not upon the block development officer.
no
He
direct.
cannot be a contender.
My lord, they
It
have
will be upon the police authorities.
asked the police authority. The police authority asked the block development officer to give the demarcation. My lord, lease was executed by the state government. They are the authority to demarcate the land. In the writ petition, I have annexed the lease deed. Now stated that we have not given the area.
The lease deed itself is area was,
Have you given a copy of the lease to the police authorities? the
yes, my lord,
condemners?
along with the writ petition. They are the party in the writ petition,
Not the writ petition, the contempt application.
contempt
Then
application.
you have served contempt application upon the alleged contemners. Have you served them with a
No,
copy of the lease?
In the
deed?
in the
Please do that. Because the order is in terms to act in terms of the lease.
yes.
So in the contempt application also, a copy of the lease deed was to be provided to the police authorities because they are the contemners.
Absolutely right.
The
My lord,
administration is not the
kindly
contemner.
come to page 24 of your lordship's order.
Yes.
The petitioner also complained that the said order was affected the interest of the petitioner granted in terms of the deed of lease executed in their favor. That is the district magistrate order. Then, my lord, kindly come to page
No,
25.
that was set aside, your
Yes, that was set aside, and your lordship directed in view of the above, the order of the district magistrate directing the catching fees by fishermen without making any payment of anybody communication to by the later dated 16 March is set aside to the extent of the area lease out to the petitioner by document executed on 27th February 2018.
Have you given this document to the police authorities? 27th February document?
Yes, already gathered.
Please show me that you have given it to the police authorities.
Along with the contempt
Contempt
application.
yes.
No, contempt application that it has
Because
not
the
been
report
annexed.
produced today prima facie
But-
suggests that they are trying.
But-
Yes, they are not sitting silent over it. Why don't you render assistance to them?
It is, if my interest is affected, my interest and we have not assist him, is it possible, my lord? And I am straightway coming contempt.
Immediately, please.
How they have served upon the petitioner, my lord, kindly produce the documents.
They
How
have
they have,
Our notices they have annexed.
how they have served. I don't know how they have served, who has received.
Kindly see page 81 of the content application. They have themselves annexed. Just for making a submission, something here, annexed the documents. It's part of the content application, my doc. What I have produced before your lordship, 50% is in the content application already. Page 81 is the notice to them. 26 June is this letter,
then
and
my
I
lord-
showed a document that is on 26th and 30th of June.
Then, my lord, kindly come to page 82 of my letter. After that,
Yes, it is being complied with.
No,
Page 81 of your contempt application.
page 81 is the letter served upon the authority petitioner, my lord.
Yes.
Then, my lord, kindly come to next page, page 82.
Yes.
I have given details what happened in this case. In terms of the solemn order of the Honorable High Court in connection with WP number so and so, I, Surodev Chaudhuri, son of so and so, manager of the Motabari Samabay Somiti, beg to draw your kind attention to that following, that 27/5 and 21/6/23, I prayed for your adequate police assistance to resume pisciculture in accordance with law in Gangapad, Islampur, Jalkot, Dag number 557, RS so and so. That in response that prayer, I was invited to be present of the pisciculture location at 9 AM. By later dated Ato, I was present there almost 6 hours. That your lordship with a team of comprising executive magistrate Malda, BDO, so and so visited the location of my Jalkot area on 27/6 at 1 PM. But in spite of my repeated requests, no steps taken from your end to help me to get the solemn order of the honorable announced in the said locality or,
From where do you get this announcement over? This is not part of the writ petition.
my lord,
Why will your order, the solemn order be announced?
solemn order announced by that district magistrate in Miking that all area has been open for catching fish.
That was set aside in
Yes.
so far as your area is concerned.
Yes, particular my area. Therefore, I am only restrained to myself to that area only.
So why don't you produce documents before the authority showing that area, that particular area?
My particular area, my lord, they himself admitted that they wrote the letter if I am not produced, it is the government record. The government authority asks me suppose I am keeping
The letter
wrong.
is written by the officer in charge. Not, the government is not involved at all.
He is the officer of the government and he has wrote letter to the BLRO. Well, who is authority, local body in that respect of that area?
Page 79.
Please hand
Well,
over
this is
this
what is
document.
happening at the ground level also.
Page 79.
This one document or one showing the area demarcation, this is the resistance being faced there to keep the contempt alive. What my learned friend is doing here, his client is doing at the ground.
Why don't you hand over this 27th February document to the police authorities? Simple.
Yes, my lord.
Kindly see the page.
79.
Nothing further is required, sir. Please hand over this 27th February document to the police authorities so that they can see what is your exact area.
That has already been annexed, page 79, my lord, our area. With reference to the above, it is written by the district land reforms officer. The Gangapad Islampur Jalpad. With reference to the above, this is to inform you, officer in charge Haradhan Dev. It has been Haradhan Dev was the officer in charge. It is written by the additional district magistrate. With reference to the above, this is to inform Gangapad Jalpad 557 with the area of Manikchor, Narayanpur, Ujan, Rajmahal to Gopalpur, English Bazar, Gopalpur to Khasgangra, so and so, so and so. The authority has given that information, what is the area. Why they are asking for me?
Where is the area stated?
Yes, first paragraph,
With area.
557 with an area,
Yeah.
Manikchok, Narayanpur, Ujan, Rajmahal to Gopalpur.
The measurement, the entire 557 is not your leasehold
Yes,
property.
yes, enter 557 is the leasehold, enter.
That is not with you. A part of the 557.
No, enter 557. Enter 557 plot is with you. Kindly come lease, original lease agreement, my lord. 557 and 557 by 1, both.
Let it be done in terms of the lease.
Yes.
Yes, my lord, but the area has to be demarcated by the petitioner. The petitioner is not in a position to demarcate his own area.
How was the lease granted without demarcation by the government?
Yes.
Yes, my lord, at that point of time, there might have been some demarcation, my lord.
So that is, that will be evident from the deed of lease itself.
Very good, my lord.
Yes, I'll give you some more time. Please come back with an affidavit of compliance. You can take this. And please assess the alleged contaminers. to
Absolutely,
help-
my lord, absolutely, because my interest is affected.
Yes.
My interest is affected.
Because just continuing with the contempt application will
No,
not really
no,
help.
no use at all, no use at all.
Affidavit of service. Paragraph, it is submitted on behalf of the alleged contemners that the order under contempt that the alleged contemners are making all efforts to comply with the order under contempt. But the applicant petitioner is unable to identify the exact area of the plot in question leased out to him. Paragraph, learned counsel seeks accommodation to comply with the order under contempt. Paragraph, let the matter appear under the same heading on 9th October. Should be sufficient.
My lord, only one thing, my lord, kindly mention page annexure P4779, that is the letter area has been defined by the district, additional district magistrate. Page 779
Of the contempt application.
of the contempt application.
ওই যেখানে ওটা বললাম ওখানে করুন। The learned counsel for the page
779.
79. Learned counsel for the alleged contemner submits that
Learned
the
counsel is
area has been demarcated by the additional district magistrate and district land and land reforms officer, Malda, in a letter issued to the officer in charge, Mothabari, PS, Mothabari police station, district Malda, on 4th July 2023.
It has gone down as learned counsel for the alleged contemner submission. It's a petitioner submission.
এটা কি বললাম? No, applicant petitioner. Thank you.
কমপ্লাই করবে না ওটা বললো তো কমপ্লাই
79.
নেক্সট কমপ্লায়েন্স রিপোর্ট ফাইল করতে এবার আমরা চিঠি
Last
দিলাম,
affidavit of compliance we submitted on that date.
এখানে লেখা আছে
হ্যাঁ।
ওই
Yes, next.
এটা বলিয়ে দিবেন এটা বলিয়ে দিল
না, প্রথমে alleged contempt submission, তারপরে এটা
Wait for one.
petitioner submission, তারপরে
কয়টা নিয়ে নিবি ভাইরা?
9th October বলেছিল।
এদিকে রেসপন্ডেন্ট এইদিকে সঞ্জয় থেকে এদিকে আসবে রেসপন্ডেন্ট
9th October, Janta. 14,
This is my application.
There are two condemners, ma'am. That is, the executive engineer will detect whether this land was utilized or not. After it was utilized, it is sent to the respondent number 3, ma'am. Two condemners is there. After our demarcation was not made, contact. Time is some time, my lord. 1 month time. In the meantime, my lord, demarcation is made, my lord. Then
1 month's time?
yes, my lord.
My lord, may I submit?
This act, then my lord, respondent number 5, that is condemner. Excluded and they are solely depend on the respondent number 3.
My lord, may I see? This is acquisition proceeding of 2013-14. ILA affected embankment. Some of the awardee has been awarded. Our award was not declared. Our land utilized, the entire land was taken over possession by notification.
You stated all this in your writ petition. That has been
Lordship.
considered.
Well, it has to be considered on the basis of my application. And they will say whether this will be governed by the new act or old act. Now they are saying it has to be demarcated. After having been utilized the land for last 10 years.
My lord, I can't.
Like
understand,
these
my lord, why the
tactics.
landed this type of submission before your lordship. Without, my lord, utilizing.
How can the exact area of utilization be ascertained without demarcation?
My lord, after
Part of
demarcation,
your representation, the entire land has not been taken.
my lord.
Part of the land has been
My
taken.
lord, notification with regard to taken over the land was published. They taken over the land. Without demarcation, how could they take over the possession in 2013?
File a fresh writ petition. This is a contempt application.
Contempt application, my lord, they are saying now demarcation.
These issues before the.
Your
letter-
lordship's order is very clear.
Yes.
They will decide the issue. If I am entitled, I will be paid. That is the,
In order to decide the issue, if they feel that demarcation is necessary, what is the difficulty? How is it illegal?
no, not illegal at this stage.
Let them do their
This is
job.
the, my lord,
It should be
Thank you.
complied with in its entirety, isn't it?
lordship.
Only a mere compliance disposing of the representation, dismissing it will not help you.
No, this,
You should be thankful that it has not been disposed of in a very slipshod manner. They are trying their best.
they are trying their best to demarcate. Now that is my question, whether before demarcation, how could they take over the possession?
Learned counsel for the alleged contemners seeks accommodation to comply with the order under contempt. Paragraph, let the matter appear on the same heading on
It will be on 9th. 9th October.
10th October.
October 10th. Demarcation ta hoye jaak. Deep.
15,
As a learned advocate, my lord, is having high fever, my lord.
For the petitioner.
Yes, my lord, Sunday, my son.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 9th October.
My lord. That will.
Next.
16,
16.
Petitioner,
Petitioner request to sign the short form.
yes.
Petitioner request to, short form.
Petitioner is, I cannot hear you. Please take the microphone. Petitioner is,
Request me, short form.
passover is not possible in this court.
And for the state, report.
None appears for the petitioners. Paragraph, let the matter appear under the same heading on 9th October. Report. Report in the form of affidavit submitted on behalf of the respondents is taken on record. Taরপরে none appeals. Next.
Lordship, 17 to 39 led by Mr. Sukumar Bhattacharya.
Yes.
He is on his leg in a division bench, Lordship.
Matters are never being taken up unnecessarily
Lordship.
or after vacation now.
Lordship, may humbly submit.
So yes,
Lordship,
come after
Lordship,
vacation.
on the last 2 to 3 occasions, he was present, Lordship.
You are the petitioner.
No, Lordship, I'm the railway authority, Lordship. If your Lordship may kindly please to fix the matter tomorrow at 10:30, Lordship.
Not possible. Before vacation, so many matters not possible. Several opportunities have been granted.
Lordship, that is, Lordship was prepared, Lordship, even on the last, the matter was fixed on.
Did it first fight again? Prothom Tani. Correct. 17.
17 to 13, Lordship, to 13, the same matter, Lordship, analogous matter.
And they agreed with the report. Now they are claiming that their report was not correct and they will submit the exception to that report. The report which was signed by them.
To their own report.
Their own report.
There's an interim.
Their
order.
own report, my lord.
There is an interim order.
Interim order is there, my lord. Status quo to be maintained. My lord, the problem is.
My lord, in this matter, my lord, that is the demarcation was made, my lord, with the aid and advice of the railway department, my lord. And they signed the report, my lord. After that, my lord, they have not any right to challenge that report. And we have handed over all the report to them, my lord, in 14 cases.
Lordship, may I humbly submit
And
one thing?
my lord, my submission is, Lordship may kindly consider that we are suffering for last 7 years, 6 years, 2017 to 2023. Out of the 14 petitioners, 4 petitioners are the agriculturists. And they live on their agricultural product. The land owned by them has been converted. And it is now unworthy and unusable for cultivation. They have filled the land with sand, pebbles, etc. And since there is an order of status quo, we are not in a position to convert the land to its original status. We cannot change the character of the land at present.
But nevertheless, the order of status quo is a shield against the railways for you.
My lord.
Isn't it? Excuse me. Come back after vacation. So many matters together. We hardly have any time before vacation.
My lord, similar matter all. One, my lord, report is there, my lord. In 14 cases, no other report is there. Only one report is there and signed by all the parties, that is BLR.
Admitting the petitioner's claim.
Yes, my lord. Now, they have not any right to challenge that report, my lord. If they want to challenge, my lord, they showed that.
My lord, may kindly fix the
9th
date for final disposal of the petition.
9th October.
9th
All
October.
matters appear to go.
Great.
On prayer of the railways, the matter is adjourned. Paragraph, let the
Every day they are
please be ready. on the
Lordship,
next
Lordship, may kindly
further
fix the time,
adjournment.
Lordship, that will be,
Time
Lordship.
is not necessary.
Because this, I can also,
It is
I
being
can.
called every day.
Lordship, I apologize, Lordship, that this matter is taken up for so many time, Lordship.
It's an old matter. It will
Lordship,
appear
Lordship,
fairly
kindly
quickly.
appreciate, we are also assisting the Lordship court, Lordship, because this is the matter is, Lord, the subject is, in the dispute is, Lordship, that it's a matter of, Lordship, national interest, Lordship. It's a huge railway track actually constructing by the railway authority, Lordship.
In the High Court, my lord, everybody is well equal.
Lordship,
That
that
railway is
body.
not a very big thing, my lord.
My lord, national interest cannot jeopardize.
We are ready?
Every day they are taking time and they are.
Lordship, can you take about 2 PM matter?
Not
Code
possible.
number
2
11,
PM,
my
not
lord.
possible. Not possible. I fixed it on 9th October.
Yes, my lord. Code now division means code number 11. Another important matter is immediately, my lord.
This is not that important.
14 matter is there, no important matter, but railway is the big matter, my lord. That is a
On
very,
prayer of the railways, the matter is adjourned. Paragraph, let the matters are adjourned. Paragraph, let the matters appear under the same heading on 9th October.
My lord, fix it. I was there, my lord, last 3-4 days I was sitting, my lord. And any time.
Next.
My lord, with regard to item number 16, there was
61.
Passover. My learned,
60 has not been passed over. An order has been passed. Please look.
if
into
your
it.
lordship kindly hears it, my lord, I am here. It was because of me, my lord. Mr. Mondol is here also, my other side.
Maybe I'm in 31 now. I cannot. go back.
31.
Yes, petitioners, 31. Anyone for the petitioners in 31? No one. Dismiss for default. You're in the full order. None appears for the parties.
32.
Thirty-one to me.
Not today, madam.
31 to me. Where is your affidavit of service? Hmm. You're in 31. What about it? Who is appearing for 11 and 12?
It's a foreign.
Give me a minute, give me a minute. Let me, give me a minute, please. I'll just find.
Mala, respondent number.
11, 12, take some breath.
Yes,
2
Mala.
minutes.
Mala,
Wait for
kindly-
2 minutes and then make your submission.
Mala, kindly not today, Mala.
No, no, no.
Mala, kindly, Mala.
No, no, you be here. I'll come. I'll pass an order.
Mala,
No,
kindly.
not today.
My senior is very ill, Mala. Kindly, Mala.
You are here.
Mala.
You will make your submission.
Mala, no have any brief, Mala. Kindly, Mala. Mala, kindly, Mala. Only not today, Mala.
First time, my lord, sir, that was received. Second time, second time also, sir.
Mala, kindly.
Service is not complete.
Last, my lord, track report. my lord.
14 has not been served.
On 9, last track report, my lord.
Where is your last?
Tomorrow. Yes,
Item dispatched, not served. This is also item dispatched, not served. Dispatch is not service.
Not update, my lord.
So you have to give an updated track report. Since service upon respondent numbers 13 and 14 is not complete, comma, let the matter appear under the same heading on complete service and comeback. Sir, we are wasting days on service.
Track report is not gonna update it.
Yes?
Track report has not been updated.
How can you be so careless? 11th October.
Thirty-three. 32.
My lord, I am for the National Ayod Office.
32.
32.
Petitioner.
I am led by Miss Monica Roy.
Ah. Petitioner. 32 petitioner, no one. This is for default. Next. Care of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 12th October.
34, 38, 30, this is
34.
In this matter, Mr. Ujjwala is appearing for the.
Which matter?
34.
34.
Ujjwala is appearing for the petitioner. Instructed, he is engaged in a due to the division. 34 to 38.
And for the state respondent.
So I'll record none appears because he's not there. Because what is,
No, I'm for the petitioner.
you are appearing for the petitioner.
No, Ujjwala is appearing for the petitioner.
So I cannot record his name because he is appearing in some other court now. He cannot appear in two courts simultaneously. None appears for the petition. Paragraph, let the matter appear under the same heading. Yes?
No. This is.
Several adjournments. Jointo, as a last, the matter is adjourned as a last chance. Paragraph, let the matter appear under the same heading on 17th October. Petitioner is not interested. 17th, 17 October.
35.
35. 38 of the one.
Same order.
36.
Same order. 38 of the same order.
37.
Same order.
We have for the state matter.
Petitioner is asking for adjournment. 17th October. Up to 38, yes.
Yes.
38.
Same order.
Thirty-nine.
No, 14, 39. Affidavit service.
Have you served the respondents? All of them?
Well, two private respondents are there and
And the
also,
state also?
yes.
Because the panel has changed in the meantime, isn't it?
No, Malad subsequently, Malad pursuant to your lordship's last order, Malad have served.
Where is the service of GP's office? Because the panel has changed.
Yes,
So
yes.
you need to serve the GP's office.
Malad, page 3 of the affidavit.
Page?
Page 3 of the affidavit of service.
Oh, it's received.
And Malad, page 5, Malad, private respondent. One private respondent is there.
Yes. Private respondent is served. No one for the state. So may I request Mr. Dey to appear? Yes, what is the matter about?
Well, I'm alleging an unauthorized construction on the PWD land, Malad, which is blocking ingress and egress to my land, Malad. I have raised allegation and wrote letter to all concerned respondent authorities, Malad. If your lordship kindly sees, there is a last order passed by Malad, your lordship kindly sees, Malad, order dated 5/7/2019. With this, Malad, copy of the order I have served, Malad.
Page?
Malad, your lordship kindly sees the last order, order passed, order dated
5th July 2019, passed by my Lord Justice Devanshu Boshak, wherein my Lord His Lordship was pleased to direct the state respondent to come with a report. And it has absolutely blocked my Lord, my residential house. My Lord, I had to my Lord, just go to the my Lord, main road by using pathway of another my Lord, neighbor. সব করেছি তাহলে
Do you want to wait for the report or let your representation?
As your lordship.
Why waste further time? Instead of spending further time on this, on the report,
No, my lord, I'm leaving it to your lordship, my lord. My lord, what is my grievance? I have just my lord, ventilated my
yes,
grievance
let
to your lordship, my lord.
considered within a state. Anyone appearing in this matter? Mute করতে বলুন। এখানে mute করতে বলুন। Affidavit of service, none appears for the respondents despite service. Mr. Der appointment regularize করুন, copy service direction.
বলে দিয়ে না চিঠি
Paragraph.
আচ্ছা ঠিক আছে
Learned counsel for the, no, the petitioner claims to be the recorded owner of the plot in question and submits that the private respondent has raised unauthorized construction by encroaching upon a portion of the PWD land adjoining his plot, comma, thereby obstructing his egress and ingress. Stop. The petitioner submitted a representation before the concerned authority in this regard on where is your representation? Page?
This one number 4 is executive engineer and 5 is assistant engineer.
Page, the representation.
Representation, my lord, page 33.
This is continuation. Where is the original representation? This is a mistake that has been rectified. Yes.
Filed earlier in petition, we withdrawn it with the liberty to file appraise because in the first representation, my lord, we mentioned the dark number wrongly. And subsequently, this is the final representation. My lord, that is we have written. That is why we have written it's a continuation because otherwise, my lord, there would have been.
This is only the correction. Where is the original letter?
The original letter 27/1/2019, my lord, page 25.
So both should be sent together. No, the petitioner sent a has submitted a representation policy before the concerned authority in this regard on 28th January 2019, which was subsequently modified by a letter dated 17th May 2019.
It dispose of corruption. Dispose of corruption.
Stop. Both the representation and the letter are yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation and the subsequent letter at the earliest. Paragraph. Though there was a direction upon the state respondents to.
My lord, Mr. Supratim Dhar is appearing on behalf of the state respondent, my lord.
Where is he? I have
Yeah.
appointed Mr. Dey. I'm sorry. Though the state respondents were directed to submit a report by an order passed on 5th July 2019 as to whether there exists any encroachment on the highway or not, comma, learned counsel for the state respondent submits that such alleged encroachment shall be determined by the authority in disposing of the representation submitted by the petitioner. Learned Counsel further submits that the 5
4 and 5, Malad.
5 is the assistant engineer.
Five and
Fifth respondent be
4 is the
directed to
executive engineer and 5
consider
is
the
the assistant.
representation in accordance with law. Paragraph in view of the above, the writ petition is disposed of, directing the 5th respondent to consider and dispose of the representation
Both representations.
dated such and such, and the subsequent letter dated such and such, filed by the petitioner, with upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondent. Within 3 months, Balaji? Within 3 months from the date of communication of this order, comma, in accordance with law.
Malad,
Disposed of.
Malad, one more indulgence. The findings of the authority, Malad, that may be communicated.
Necessary, because section 10 proceeding, you will be given, you have to be given an opportunity.
Because Malad, if I have to come, Malad, for the second time, Malad. Malad, that is the practice, Malad.
Why will you have to come at?
Because it will not probably in all cases, Malad, it is not completed in Malad one writ petition, Malad. They will take step and they will sit tight. Malad, they will not.
In all the cases, proceeding under section 10 is being initiated. There is no other second option. Joint 40. Joint Minister Dev Nam will cut course, none appears.
I have the petition.
No. Okay, allow coding. Yes.
I am for this. But a construction has been made by the private respondent. But on PWD land, Malad, just in front of the land of the petitioner, house and land of the petitioner.
Have you served who is appearing for the private
Malad,
respondents?
I have served, but they have received.
For the state, yes.
I have served, Malad, can you see? I have served upon all the respondent earlier and also now, Malad, have served.
All delivered?
Yes, on 11th. On 11th, Malad, it has been delivered.
Yes.
But of petition.
PWD land.
Yes, PWD land, Malad.
Page 11 is your report.
Yes, my representative is 11. And I have mentioned paragraph 2, the land of the petitioner, Malad.
Yes, will this be considered?
Do I have to take instruction, but your lordship is
What
pleased to?
instructions?
No, my lord. If your lordship pleases to direct for consideration, it will work.
If they find demarcation, they'll initiate proceedings. No further instruction is necessary at this stage.
Because the PWD, they cannot
demarcation
because the PWD land.
Before that demarcation will be done thereafter. My lord.
That's the entire process, isn't it?
Yes.
Affidavit of service. Paragraph, none appears for the private respondents despite service. Paragraph, the petitioner claims to be the recorded owner of the plot in question and submits that the private respondents have raised unauthorized construction by encroaching upon a portion of PWD land
Yes, Malad.
adjoining his plot, thereby obstructing his egress and ingress. Stop, the petitioner submitted a representation before the concerned authority in this regard on 4th September.
Malad.
4th
4th
September
September
2019.
2019,
Malad.
which is yet to be considered. Stop, the petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the state respondents that the 5th respondent, assistant engineer,
My lord.
5th respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, that the petition is disposed of, directing the 5th respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, in accordance with law, disposed of which.
Your lordship are related to conduct the hearing within 3 months.
Conclude, yes.
Conclude the hearing in accordance with law.
Yes, obviously good. Yes, I know. My lord.
My lord, before your lordship takes up the next matter, my lord, item number 6, petitioner is there, my lord. Your lordship has directed the matter to appear on 28, but 28 is the sectional holiday. Can your lordship take up any another day?
Who you are appearing?
I am for the state, he is for the petition.
Item number 6.
6, your
I
lordship,
don't even know what order has been passed.
your lordship has directed to matter to appear on 28th. Only this was the order.
So 29th,
Yes, 29th.
Amlan, একটা note রাখুন তো। দিদি, item number 6 to 29th হবে, 28th এ যায়। বসু, বসু।
লিখে দিন, Great.
Yes, 41.
I am for the petitioner 41.
I appear
Yes.
for the KMDA.
I am for the
There are 4 matters.
Yes,
41, 42, 43, 44 are identical.
yes, Miller 41, your lordship kindly take up first. Here I have challenged the acquisition proceeding initiated by the state government. My point is that 1984, section 3 notice was issued. Only and the declaration was made on 1987. And before that, your lordship kindly come after section 3 notification, possession was taken. Your lordship kindly come to the report of KMDA. Report of KMDA.
Yes. Yes.
Page 6. Page 6 of that report.
Yes.
Certificate of possession of land made over to the parties on whose behalf it has been acquired. Certified that I have this day, 18/10/84, received symbolic possession. Symbolic possession by the order of Honorable High Court at the hands of Sri A. Gupta, Special LO, on 9183 acres of land situated in village Bangra, PS Domjur, district Howrah, for the purpose of West Howrah development. So, symbolic possession by the order of the Honorable High Court. That was taken 18/10/84. Your lordship kindly come to the order of the Honorable High Court that I have annexed in my writ petition. Page 45.
Yes.
Page 45, that is the order dated 17 September 1984 by D. Ajit Kumar Sengupta, as his lordship then was. Your lordship kindly come the operative portion of that judgment that will appear from page 54.
54.
Yes, madam, 54.
Yes.
From the top, I am reading internal page 10 of that judgment.
Yes.
It will ensure benefit of. In this case, the entire vacant land of the village is being requisitioned for the West Howrah development project. Such lands includes both agricultural and non-agricultural land. If all the lands are taken possession of at the same time, then the agriculture will be in great difficulty and in distress, particularly those who are entirely dependent on the cultivation. But a balance has to be held between the competitive interest, having regard to the magnitude of the problem and the object for which lands are being acquired. I am of the view that the following direction should be given to the respondent. The respondent shall take symbolic possession which they have taken
of the vacant lands, except in those cases where notices have been issued against the dead person. The respondent shall issue fresh notices upon the proper person and thereafter shall take symbolic possession of such land. At the time of taking symbolic possession, the respondent shall make a survey how the lands which are being taken possession are of use by the owners. Second, II, the respondent shall not take any step for acquiring the lands until the present cultivation season is over and harvesting is complete. In the meantime, 3 III, in the meantime, the respondent shall assess the market value of the lands provisionally and shall pay 40% of the compensation on the basis of market value to the owners of the land to enable them to have a new source of livelihood where such persons are entirely dependent on the said lands. 4 IV, the respondent shall take actual possession of the lands after payment of 45%
75%.
of the compensation as directed by this order and thereafter the harvesting season and in any event not before 15 January 1985. So, Milo, the court has directed to take them symbolic possession and to take actual physical possession after payment of 45% of the compensation amount.
After payment of 75%.
Sorry, 75% of the compensation amount.
Yes.
When compensation amount arises after the award is declared. Now, your lordship kindly come to the report of state.
So you're admittedly a subsequent purchaser.
No, my contention is that the acquisition proceeding lapse. After lapse of the acquisition proceeding, I purchase.
Yes.
Your lordship knows, section 11A
Yes.
of the Land Acquisition Act 1894, period within which an award shall be made. If your
Yes.
lordship kindly take 1894 Act.
Yes.
Now, Act 2 is no longer in existence. Only this Act is prevailing in the field. 11A. Period on which an award shall be made. The collector shall make an award under section 11 within a period of 2 years from the date of the publication of the declaration. And if no award is made within that period, the entire proceeding for the acquisition of the land shall lapse. Here, Miller declaration was made 1987. An award was made 2004. So acquisition proceeding lapsed. And I purchased 2004. Now, your lordship kindly come to the report of the state.
Yes.
Report of the state.
Yes.
Paragraph 5. Sorry. Report of the state manor. Report of the state, kindly come to page 5. Possession of paragraph 2. Possession of the suit land, that is RS plot number 301 under Mauja Bakra, PS Domju district Howrah, was made over to the Kolkata Metropolitan Development Authority on 18/10/84, where the KMD has stated they have taken symbolic possession pursuant to the order of the Honorable High Court. Under the provision of Act 2 of 1948. Subsequently, Gazette notification bearing number such and such, dated 27 March 1987, was published in the Calcutta gazetted extraordinary on 7/4/87. Next para, award in respect of the suit plot land was also declared and on 18/10/2004 by the collector Howrah. That is about 20 years. After declaration, the award was passed after 20 years. But section 11A says it must be done within 2 years.
Yes.
Apart from that, section 4 notice not only has to be gazetted, but it has to be published in the 2 newspapers. One must be a local newspaper or local vernacular. That has not been done in the present case. So my first point, Honorable High Court's order was not complied with, so far this acquisition proceeding is concerned. Honorable High Court directed to take actual physical possession after payment of 75% compensation. But compensation was, compensation or award was passed 2004. So the Honorable High Court's order not complied with. So actual possession has not been taken till date. Because the actual physical possession has to be taken after payment of 75% compensation. That has not been done. Even in the compensation, they have annexed the copies of the check. The check number is different, same, but amount is different, and the names of the person in whose favor award has been published are the same. I don't know why a same check number can be issued in the name of different person. But that has been annexed. If your lordship kindly come to page 17.
Yes.
Page 17, state report.
Yes.
That is Prabodh Chandra Bandyopadhyay. That is my vendor's name. Right hand side, your lordship kindly see under section 30 numbers with check number 362259. Has your lordship got it?
Yes.
362259. Next page,
Numbers are different.
name is different.
Yes.
Prashant Samar Bandyopadhyay. Same check number 362259. Right hand side. Has your lordship got it?
Yes. Yes.
Next page, page 19. The name is Pulin Bandyopadhyay. Check number is 362251. But the amounts are different. The names of the persons are different. How can it be possible? This is manufactured document. Same check cannot be issued in favor of 3 or 4 persons. Though amount is different, persons are different. So this is a manufactured document. That is my respectful submission. So no award has been passed till today. And after the lapse of the acquisition proceeding as per section 11A of the Act, I purchased 2004. And
You are in possession?
yes, I am in position.
Physical position?
Yes, I am in physical position because they have taken only symbolic position. Because pursuant to the order of the Honorable High Court, they can't take physical position unless payment of 75 for compensation.
That's all your submission?
That is submission.
May
And
May I respond?
section 4 notification not
Let-
published
let-
in newspaper.
Let us respond one after another. So far this matter is concerned, Miller. Look, there are many things to submit. Miller Lordship will be surprised to see that. First of all, Miller, may I invite your Lordship's kind attention to the writ petition. Paragraph 1, certain portion, Miller, I will indicate. Page 3, Lordship will find that your petitioner is citizen of India, the last line. The petitioner is a member of Bankra Nagori Co-Forum. That is co-verdict.
Paragraph?
paragraph 1 at page 3.
Yes.
This petitioner is a member of that forum, that Bakra Nagarik committee. He has cited in other paragraphs. And the next paragraph, paragraph 2, Lordship will find that the petitioner by a registered deed of conveyance dated 26 July 2004 purchased 8 kata 2000. So this petitioner has purchased in 2004, July 2004. Now Lordship kindly skip to paragraph 12. The petitioner, Milord, why I am referring, Milord, I'll submit. The petitioner has come to know that the Bakra Nagorik Forum, a registered association to which he is a member, this petitioner is a member, claims to be the member. Registered association for looking after the interest and rights of all the villagers of village Bakra and 6 other persons moved an application under Article 226 of the Constitution of India, being civil rule number so-and-so of 84, challenging the purported attempt to requisition all the lands in village Bakra, PS Domju, district Howrah, which came up for hearing before the Honorable Mr. Justice Ojit Kumar Sengupta on 17 September 1984, when his lordship was pleased to dispose of the writ petition by passing the following direction. This direction, my learned friend has already read out from the judgment annexed. I am not troubling your lordship. These are the quoted here. And it is the claim throughout the writ petition, the sheet anchor of the writ petitioner is the order passed by Honorable Justice Sengupta. That order, since not complied with, the proceeding has gone, is vitiated. And this is what,
Section 11,
and this is what in so many paragraphs cited this. You will find at page paragraph 16 at page 11. The statements made, the petitioner states that even after the said judgment, an order dated 17 September 1984, that is that directions, passed in CN number 16526, the respondent did not take any further step on the basis of the said judgment and order dated 17 September 1984. The respondent did not take any land of village Bakra and did not assess the market value of the land provisionally by serving any notice, as no notices in respect of land of the petitioner were either served upon the petitioner or upon the previous owner of the land, plots of land. The question of payment of any compensation in respect of the lands of the petitioner does not arise at all. So now Lordship will kindly, for a moment, kindly see that prayer. This starts from page 18. Well, I am not reading the.
So you say that the requisition doesn't cover the petitioner's land at all?
No, I'm indicating this challenge was that in earlier writ petition moved by the Nagorik Forum, that's CR number, there were certain directions. It is alleged in the writ petition, those directions were never complied with.
Yes.
And that writ petition was moved, challenging the same land acquisition case, that is LA 25 of 1984-85. And
at that time, no acquisition proceeding was started. Before that, because we heard that there will be acquisition proceeding, that is why it was moved.
And prayer has been made for quashing of. Lordship, kindly have a look. It starts from page 18. A writ of or in the nature of mandamus do issue directing the respondents and or each one of them servants to subordinates to act in according to law by not including the plot of the petitioner in LA case number so and so to recall revoke the purported land. So this is the challenge to the same acquisition proceeding, that is 25-2 of 1984-85. And what my learned friend has Miller submitted, that he has purchased the land after the proceeding was lapsed.
whether any ground has been taken to that effect. Lordship will kind, I have not found any of any grounds taken in the writ petition. So here Lordship will find that the challenge to the proceeding is LA case number 25. Now Lordship kindly come to this fact my learned friend has not disclosed. This should have been disclosed because he himself appeared in all those proceedings. In 2004, this Bakra Nagorik Forum, which had earlier moved a writ petition, had filed a writ petition. And my learned friend appeared for the petition. Lordship will find.
Is this part of your report?
No, I come to learn, my lord, subsequent.
No affidavit has been filed, only report.
Yes,
Come back
let
with
us,
affidavit.
let me place.
দেখি একটা copy।
আমার আজকে আর কপি আনিনি আমি I will supply copy. Just when yesterday, my lord, I got hold of this. May I read, my lord? This is 27 July 2010, order dated, and writ petition of 2004. My learned senior friend appeared for the petitioner. May I read this? And the whole order is very relevant. In this writ application, the petitioners have challenged the entire acquisition proceeding being LA case number 25, Act 2 CMDA of 1984-85. This is the same proceeding, as illegal and invalid on the ground that there was no notice of acquisition of land as provided in subsection 1A of section 4 of the Act 2 of 1948. A notice of acquisition under section 4(1)A was published in the Gazette on 7th April 1987. The entire basis of the challenge in the writ petition was want of notice under section 4(1)A of Act 2 of 1948. The grounds thus fails. Mr. Mondal, appearing on behalf of the petitioner, referred to an order dated 17 September 1984. In this writ petition also he is referring to this, passed by his lordship, the Honorable Justice Ajit Kumar Sengupta, as his lordship then was, in civil rule number so-and-so of 1984. His lordship issued the following direction. I am not reading this. These are the same directions which my learned senior friend has read. The order dated 17 September 1984 restrained the respondents from taking actual physical possession of the land in question till the cultivation season was over and harvesting was complete. The respondents were, in the meanwhile, directed to assess the market value of the land provisionally and to pay 75% of the compensation on the basis of the market value to the owners of the land, to enable them to have an individual source of livelihood where such persons were entirely dependent on the said land. The respondents were directed to take actual possession of the land after payment of 75% of the compensation as directed by the order, and in any case not before 15 January 1985. The original writ petition has been amended. Even when amended writ petition was filed, the petitioners were still in possession. There were a restrained order restraining the respondents from taking possession before the end of harvesting season, that is before 15 January 1985. Possession was not taken before 15 January 1985. The records pertaining to the case were produced. Award of compensation has been declared and in most cases disbursed after giving the owners opportunity of hearing. Mr. Mondal, appearing on behalf of the petitioner, did not dispute the fact that the notice under section 4(1)A of 1948 has been issued. Mr. Mondal also did not dispute the fact that the award of compensation has been declared. Mr. Mondal submitted that the respondent had acted in violation of the order dated 17 September 1984. In that 75% of the compensation had not been paid in advance. On a reading of the order dated 17 September 1984, it is clear that his lordship did not restrain the respondents from further proceeding with the acquisition before payment of compensation. The respondents were directed to pay 75% of the assessed market value before taking actual physical possession. There is not a whisper even in the amended writ petition to the effect
that the physical possession had been taken without award of compensation. Mr. Mondal very rightly argued that any action in contravention of an order of court is a nullity. However, this court is unable to hold that the acquisition in this case is in violation of any order of this court. The writ petition thus fails, and the same is. Miller, this is the final order passed in the writ
Petitioner
petition.
got the compensation.
Yes,
Here
yes.
they did not got the compensation.
Sir, আমি কপি দেবো
And
আপনাকে।
award was not passed.
My lord, before, at the interim stage of the writ petition, challenging an order, an appeal was preferred by us. They came
In the
Lordship,
earlier writ petition.
in this writ petition. Because these orders are very much relevant, my lord. That is why I am referring to, sorry. Because the situation try to, my lord, show to this honorable court is not the real picture. Lordship will find. একটাই আছে, sir.
Unreported judgment you will produce.
I'll supply, I'll supply.
Unreported judgment.
I'll supply, sir. দেবো।
Not fair.
My lord, this is, my lord, order dated 17th December 2004 on an appeal preferred by us against an interim order.
Yes.
After having heard the learned counsel for the respective parties, it appears that the delay has been sufficiently explained, inasmuch as after the order was passed, steps were being taken to get the order vacated. But for some reason or the other, the matter could not be taken up, and as such, the delay. The urgency that has been pleaded that a very important subject for which funds has already been given, casting liabilities in default, are to be utilized forthwith. The ensuing vacation is posing an apprehension to the appellant that the matter might be further delayed. Therefore, the present appeal has been preferred along with an application for leave to appeal and an application for condonation of delay. After having heard the learned counsel for the parties, we allow both these applications being AST number so and so, we grant leave to prefer this appeal and condone the delay. Let the appeal be registered. In view of the urgency pleaded by Mr. Bhattacharya and Mr. Roy, the learned advocate general, by consent of the parties, the application for stay being AST number so and so is treated as on day's list for hearing. The respective learned counsel for the parties had addressed the court on the question of stay on merit. We propose to dispose of the application for stay in the following manner. In this case, pursuant to a project planned in 1976, the land was sought to be requisitioned in 1984 under the West Bengal Land Requisition Acquisition Act 76. Plan. Pursuant to a plan conceived in 1976, that has been. A writ petition was moved challenging the said requisition being CO number 16526 W of 1984. That is that writ petition. Since disposed of on 17th September 1984, that is the same date, the 17th September, by Honorable Justice Ajit Kumar Sengupta, as his lordship then was. In the said order, the following directions were given. I am not reading, I am skipping to these directions, my lord. Next page, page 4. It is contended on behalf of the state by Mr. Rai that the 75% of the compensation in terms of the said order was deposited in 1986. However, Mr. Mondal, my learned senior friend, appeared in that matter. Mr. Mondal, for the writ petitioner's respondents, contends no notice of such deposit was ever given to his clients, and his clients are not aware of the same. A notice under section 41A of the 1948 Act was given in 1986. Pursuant to the said notice, it is contended that since it is a notice under section 1948 Act, the date of issue of the notification shall be the date of vesting of the property in the state. It is also contended that on account of requisition, the possession, whether physical or symbolic, would be with the state, though physically it may not be in the possession of the original owner. Mr. Mondal, however, contends that the possession was never taken and his clients are in possession of the property. Mr. Mondal submitted that in an affidavit, the appellant's KMDA had contended that 80% payment had been made in 1990. Be that as it may, it is neither here nor there. Now, question is whether the order of status quo since appealed against is to be stayed or not. There is no doubt about the urgency and the purpose of acquisition, though it is contended that the 1948 Act has since lapsed. Yet that would not matter since the proceeding for determining the compensation was over before 1948 Act ceased to exist. However, on the cessation of 1948 Act by reason of amendment incorporated in Section 9 of the Land Acquisition Act applicable to West Bengal, the proceeding for compensation can still be pursued and carried on under the Land Acquisition Act with regard to the reference, etc. out of such award, provided the limitation has not set in. All these questions shall be determined at the time of hearing of the appeal. It may be noted that in the decision dated 17 September 1984 in CO number 16526 of 1984, the requisition was neither quashed nor held to be irregular or illegal. Admittedly, no appeal has since been preferred against the said order. Thus, the said order has reached its finality. Therefore, it appears that the validity of the requisition is no more open to challenge after the said decision. The directions contained in the said decision clearly indicate the entitlement of the claimant to compensation. The directions were aimed at protecting the interest of the claimants in receiving the compensation. The said directions contained mode, method, and manner of taking possession upon payment of 75% compensation. The rights of the writ petitioners therein who have preferred the present writ petition are confined only to the receipt of compensation and nothing else. That apart, the said decision would operate as constructive res judicata, even if the present questions involved in the present writ petition were not raised in the earlier writ petition, but could have been raised, were deemed to have been raised and decided against the petitioner. This part is very important. Thus, it is crystal clear, prima facie, that there is every little scope available to the writ petitioner in the present writ petition to obtain any relief other than those which were provided for them in earlier writ petition. Prima facie, we are of the view that there is practically no scope or prospect of the petitioners being successful on the question raised in the present writ petition, not only on merit, but also on the ground of delay. Apart therefrom, Mr. Mondal had contended that the original claimants had in the meantime transferred their interest in favor of the present petition, who have stepped into the shoes of the original claimants. According to him, the valuation of the land has increased phenomenally, and that no possession having been taken and the validity of the requisition having been challenged and the 1948 having lapsed, the proceeding cannot continue. The submission of Mr. Mondal is devoid of any substance. If the petitioners are transferees subsequent to the requisition in the absence of original owner at whose hand the lands were requisitioned, the transferees cannot raise any question with regard to the validity of the requisition or the acquisition, as the case may be. Post-requisition, acquisition transferee acquires no interest in the property, requisition or acquisition. The transferee acquires only a right to the compensation and nothing else. If the award is already made, they would be entitled to the award, and if it is still open to seek reference, they would be entitled to seek reference for enhancement of the amount of compensation. Their right is limited only to that extent and no further. Thus, we find there is a very little scope to sustain the writ petition and to continue the interim order of status quo, having regard to the facts and circumstances as discussed here in above, as well as discussion made hereafter. However, it appears that the purpose for development of a satellite town, which is one of the essential services contemplated under the 1948 Act, and therefore validity of the purpose prima facie does not seem to seem that the same can be assailed. The only benefit the petitioners can get is an added compensation or enhanced compensation in case the requisition or acquisition is set aside. In that event, the state is free to issue a fresh notice to acquire the same, which will enable them only to claim enhanced compensation. Then, my lord, the reference to some cases, my lord, I am skipping to the last paragraph. In the circumstances, without prejudice to the rights and contention of the writ petitioners, respondents, we direct that the operation of the order of status quo passed in the writ petition, since appealed against, shall remain stayed. The order will continue for a period of 60 days after Christmas vacation, within which the amount deposited as compensation shall be released in favor of the persons. This part is very important. Shall be released in favor of the persons after identifying their entitlement, provided the individual claimants apply for release of this amount before the collector, Howrah, who will dispose of each such application within a fortnight and latest within 4 weeks from the date of making such application. However, the period till making such application in each individual case shall be excluded for the purpose of counting the 60 days during which the stay shall remain operative. The receipt of this compensation by the respective claimants shall be without prejudice to their rights and contentions in the writ petition and the appeal, and to seek reference if they are entitled in law, and also to claim enhancement of the valuation if any reference is made. This order is also subject to further orders that may be passed in this appeal. We, however, keep it open to enhance compensation already awarded in terms of the appeals court judgment that judgment referred to above at the time of hearing of the appeal, if the circumstances so warrant. We keep all points open in case any application is made and the amount has not been released on account of any dispute with regard to the claim. In that event, the same should be referred to the learned district judge under section 30 of the Land Acquisition Act for apportionment or appropriate decision. In case any amount despite being payable to the claimant is not paid, in that event the collector shall prepare such check and bring the same to this court on the date when the appeal is fixed for hearing. While releasing the amount, the solatium, additional compensation and interest as payable in terms of section 7 of 1948 Act, read with section 23 of the Land Acquisition Act, shall be included and paid. It will be open to Mr. Mondal's client to receive the principal amount immediately on the application, and the collector shall determine the amount of solatium, additional compensation and interest within a fortnight thereafter, and pay the same within 6 weeks of the making of such application. In case any additional fund therefore is needed, the collector shall forthwith inform the KMDA, which will furnish such fund forthwith. The collector shall hang up a list of the claimants in the office of the collector within a fortnight from today. The application for stay is thus disposed of. Since all parties are appearing, the appeal is treated ready as regards service. All formalities are being dispensed with, requisite number of paper books, so and so. Since the decision in this application and the decision in the appeal will affect the decision in the writ petition, in view of the urgency of the matter as well, and for the sake of convenience and for shortening the litigation, it is expressed by the respective counsel for the respective parties that it is desirable that the writ petition should also be disposed of along with the appeal. By consent of the parties, the records of the writ petition are hereby called for in order to decide the same along with the appeal. Both the appeal and the writ petition will be listed at the top as specially fixed matter on 2nd February 2005. Then, my lord, this appeal again appeared pursuant to this direction. This appeared on my lord, may I read? This is, my lord, pursuant to the earlier direction, it came up for further consideration on 8th February 2005. on 17th
No,
September.
previous judgment in respect of a status quo order, but the judgment which I placed before your lordship, there is no order of status.
These are all subsequent to the
Subse-
the said
subse- sub-
judgments.
I will
Maybe,
supply all the
but this is
copies.
against the order of status quo.
Yes.
I
this
do
is
not
the
know where
appeal
is the,
also.
why is the order of status
There
quo
is an
coming.
appeal also, sir.
But
Anyway,
there
let's-
are four directions. No status quo order was there in the
these
judgment.
judgments decide the present writ petition also, I'm afraid.
No,
I-
no, no,
I-
no.
I will supply the copies. You will consider all this. Since I am citing unreported, I must supply the copy.
It
Milord-
deals with the same acquisition case.
Same acquisition. That is why I pointed out some
Not
portion
only
from
that,
the writ petition.
I should say this is suppression of material facts also on the part. of
Yes, on the ground alone, apart from delay and all other grounds.
No, section 11 was not considered.
Suppression of material facts. You have not placed these judgments before this court.
Lordship,
The
kindly,
same acquisition, yes, please continue.
yes, kindly allow me to this. This order will end everything.
Let them place on affidavit.
These are judgments.
These
of
are
this
the
court.
these are order of the court.
But
Judgments of this court need not be.
but
placed
in
on
the affidavit, they have not stated so.
These are judgments of this court not required to be stated by affidavit.
Even
A
the-
copy will be supplied. to
Even
you,
the
sir.
honorable court can take judicial notice of these.
Please serve copies
Yes,
to the.
may I read? This is, yes, I shall supply all the copies. I told.
Not reported judgment. I am.
Not- yes. I mean, from the very beginning, I could not copy it. That is why, Milord, otherwise I would have. Milord, this is 8th February 2005. On 17th December 2004, we had passed an order, that is the earlier order, Milord, 17 December referred to.
Yes.
On 17 December 2004, we had passed an order pursuant to which payment were to be made to the claimants. Mr. Banerjee, appearing with Mr. Bolai Roy, the learned Advocate General, submits that the payment have since been made. 7 of the writ petitioners have received the checks. Mr. Mondal, learned advocate for the respondents claimants, submits these 7 persons are not the writ petitioners, but admittedly they are claimants. 21 checks have been shown to us which have been made ready for payment, but no one has come to accept the same. A list of claimants has also been produced. A copy of such list is handed over to Mr. Mondal. The claimants may approach before the land acquisition collector and receive the checks without prejudice to their rights and contentions, provided the checks are issued in their name. In case of any dispute with regard to the claimant, in that event, he may apply to the land acquisition collector, giving particulars of the rights under which the claimant is making the claim, and the land acquisition collector shall exercise his power under section 30 of the Land Acquisition Act and determine the person to whom the compensation is payable, and after such determination, he shall pay the amount of compensation to such person. This exercise must be completed within a period of 1 month from the date of making of such application. In case it is not possible by the land acquisition collector to make the payment, in that event, he will communicate in writing to the person indicating the reason for his inability to make the payment. In such case, the land acquisition collector shall make a reference to the court under section 30 of the Land Acquisition Act within a week from the date of his decision. The court to which the reference is made shall determine the case after giving notice to all the concerned parties in accordance with law as early as possible, preferably within a period of 6 months from the date of such reference. Mr. Mondal, however, contends that there are certain other claimants who are recorded owners, but no payment has yet been made. Xerox copies of such applications are being produced before this court. Let the Xerox copies be handed over to Mr. Banerjee, who will pass on the same to the officers of the land acquisition collector. After receipt of the said copies, of the land acquisition collector shall scrutinize the applications and find out whether they are recorded and they are entitled to get compensation. In that event, the land acquisition collector shall make payment of the compensation within a period of fortnight from the date of making of such application. In case it is necessary, he may exercise his jurisdiction under section 30 of the Land Acquisition Act, and he may decide the same or refer the case to the court if occasion so arises, and or the same direction as has been given earlier in the order. There is a correction, some correction shall be repeated in this. There are other claimants who claim to have purchased the interest of the original owner. These claimants shall make appropriate application before the land acquisition collector, together with particulars of their claim and the copies of the relevant documents, the original whereof are to be produced in course of hearing. Upon such application being made, the land acquisition collector shall give notice to the respective parties and determine the question whether within a period of 4 weeks from the date of receipt of such application in accordance with law, and in the same manner as was directed earlier herein before. Even the subsequent purchase of the provision directions were given. The project, however, shall continue and shall not be forestalled for any reason whatsoever. In case of any dispute with regard to the claim, the same may be subject to the further order of this court or a reference under section 18 if it is so preferred. The claimant shall be at liberty to apply under section 18 if they are so advised, if such application is not barred by law. However, we repeat that the payment and receipts of the compensation by the respective parties are without prejudice to the rights and contention of the parties in the appeal, subject to further orders that may be passed by this court. Let this appeal for hearing so and so. But this order.
Yes.
Yes. So, my lord, later on the appeal was disposed of, my lord. I could not get the order, but I could get the date, my lord, on 11th May 2007, holding the same.
Decide the order on the next.
Yes,
Though these orders are very clear.
very clear.
Only the.
And the writ petition,
was left
and this is the writ petition in which this order was passed.
We'll continue on some other day.
In another proceeding, this writ petition along with the appeal was called for, because there also the similar question arose regarding the order of Bakra Nagorik Forum. There, my lord, I could learn that. Yes. So this, my lord, after this, my lord, nothing remains, and this should have been disclosed by this petitioner. When the petitioner can remember the 1984 order, the petitioner cannot remember the 2004 and 2005 order. That can't be believed. Without making aspersion on my learned senior friend, Miller.
I will not make any comment on the merits at the moment, because let us hear out the matter.
Yes,
But this is gross suppression of material facts.
Yes.
Your writ petition needs to be dismissed only on this ground, without going into merits.
I will make my submission because the present writ petitioner are not there in the earlier.
They are also covered by these judgments.
No.
It is recorded.
But these petitioners were not in any earlier proceeding. These writ petitioners.
The petitioners who were not parties to the earlier proceedings are also covered by these judgments.
No, that can't be, because
It is
statutory.
recorded, and the judgments are not challenged. They hold the field even till this day.
No, we are not the parties in the previous writ proceeding.
Not necessary, sir.
We are not parties.
Not necessary. Come back, there is an order. The order is very clear. Please go through the orders and come back.
I shall supply the copies to my learned friend.
Mr. Mondal was representing them in the.
He was
This is
before the
gross
writ court,
suppression
appeal
of
court,
material
everywhere he
facts.
was.
Even without going into merits, I would like to dismiss the matters only on this ground. Heard learned counsels for the parties. Paragraph, let the matter appear under the same heading for further consideration on October 10th. Please serve advance copies, Mr. Talukdar.
Yes, let me get the copies of it.
These are not
So
reported.
that
I shall supply. My lord, at the very beginning, my lord, I could not say all four.
Same order?
41, 42, 43, 44.
Let
Up
them
to
appear
40.
one by one together.
Yes.
Up to 40,
44.
up to 40.
Maybe 41, 42, 43, 44, same order.
10th October. Thank you, no?
Mention matters item 320.
320, I beg to have with the petitioner. It is a petition of the. Ultan. No, এটা তো তুমি বাদ।
Yes.
Lord, may I submit the affidavit?
Mr. Dey is appearing? Yes, madam. Any private respondent?
No, madam, no private response there. This matter, my lord, I am led by Mr. Kullan Kumar Bandyopadhyay, my lord.
You'll continue?
I will argue. Interim order is required because, my lord, interim order is required, my lord, because there is threat of, my lord, creation of a third party interest over my leasehold right, for which, my lord, I have invested more than 3 crores of rupees.
The lease is cancelled.
Lease has been cancelled, but pursuant to your lordship's direction, my lord, that was reconsidered. But, my lord, the decision was prejudged, and, my lord, it was passed without, my lord, hearing the petition.
What is the wrong in it?
Yes.
No,
Your
let-
lordship will see what is the wrong in it.
Let me finish. আপনি বলবেন সুযোগ আছে।
Is the wrong?
Yes.
Well, this is 4th round of litigation. My lord, company, my lord, Bharat Electrical Industries Limited, my lord, owned up by person to the order of this honorable court. My lord, the movable and immovable assets of the company was, my lord, put on auction for sale. My lord, the government of West Bengal, my lord, purchased those property on auction. My lord, for rehabilitation and, my lord, the further development and restart of the unit, my lord, the government of West Bengal, my lord, floated tender. The petitioner, my lord, participated in the tender, and, my lord, he was declared a successful bidder. My lord, a lease deed was entered into between the government of West Bengal and the petitioners. My lord, the prime condition of that lease was, my lord, the petitioner had to pay, my lord, 80 lakhs as, my lord, lease premium, and, my lord, 60 lakhs for, my lord, the machineries and factories and all these things. Now, my lord, may I place, my lord, the first one, lease deed. Some clauses are very important, my lord. My annexure P1, page 47, lordship kindly, this is the lease deed dated 8 November 1996. Lordship kindly directly come to page 59, clause 3C. My lord, 3C, my lord, the lessee will use the demised premises or permit the use thereof only for commercial purposes, namely for the running of an industry. My lord, kindly note in, my lord, no particular item or no particular, my lord, unit has been mentioned. Page 59. For the running of an industry, etc. In particular, the lessee shall not use the demised premises for any religious purpose or as cremation ground. This is the only restriction. But I can start any business over that property. Now, my lord, the next page, my lord, clause D. The lessee will absorb in the industrial unit to be started by the lessee at the demised premises at least 120 of the ex-workers of the company, Bharat Electrical Industries Limited, now in liquidation, who are on the payroll of the said company on the date when it was closed down. And in this respect, the lessee unconditionally binds itself to comply with the provisions of the memorandum of understanding dated 22nd July 1994, executed by and between the promoter director of the lessee, Sri Anup Kumar Shah, and the representative of the ex-workman of the company. Now, my lord, the next clause is, my lord, page 61, clause G. Clause G, my lord, 3G. But the lessee shall, as soon as practical, start running its factory at the demised premises after complying with all the rules, regulations, and government orders. Now, my lord, at the bottom, my lord, your lordship will find, my lord, clause number 5C. The lessee shall be at liberty to be in and set up all machinery, plants, and equipments on the demised premises as it may consider necessary, Next, my lord, page 62, clause D. This is very important, my lord. The lessee shall have the right to assign, sublet, or transfer its right, title, and interest under this lease, wholly or partly in any portion of the demised premises, without prior consent of the lessor. But such rights shall always be exercised subject to the provisions of this lease, and in particular the provision relating to the commercial use only of the demised premises. Next, my lord, the subject to subclause F below, the lessee shall also be entitled to mortgage, charge, or otherwise encumber its right, title, and interest under this lease in such manner and on such terms and conditions as may be decided. But on these terms and conditions, the lease deed was executed. And my lord, simultaneously with the execution of the lease deed, my lord, I paid 30 lakhs rupees out of my lord 80 lakhs. And my lord, for the machineries and factories and all other liabilities towards the workmen, I paid 10 lakhs. And it was, my lord, the condition precedent that the rest post balance amount of premium I have to pay by monthly installment. So, my lord, after getting possession of the property, both movable and immovable, and after entering into the lease, my lord, deed, my lord, I started taking, my lord, steps for restarting the unit by, my lord, repairing the factory shed, by, my lord, applying for taking necessary approvals, permissions, all these things. Now, in the meantime, my lord, the petitioners were dragged into several litigations, my lord, by the workmen of that company, in liquidation. That has been admitted by the government also. My lord, for that purposes, my lord, I could not restart the unit well within the time. And my lord, I also, my lord, I wrote a letter to the, my lord, the concerned authority stating my predicaments. My lord, kindly have a look, my lord, annexure P2, page 66. This is, my lord, sorry. Page 63 is, my lord, the machineries and all other things were, my lord, page 73A.
Yes.
This is, my lord, the copy of that letter, my lord. Dated, letter dated 24th March 2006.
Yes.
Subject progress of restarting of our lamp manufacturing unit at Behala. Letter, reference letter number such and such for Assistant Secretary IR Department, sir. As reference to the letter under reference informing us about the meeting fixed by you on 8/3/2006 for discussing the above subject. Unfortunately, the letter was received only on 7/3/2006 while I was away on tour, and hence I could not meet you on such and such date as directed. My officer intimated the matter to your department by letter dated such and further contacted the Assistant Secretary IR Department over telephone to know whether you could meet me either on such and such date when I was supposed to be in Kolkata, but we did not receive any confirmation to this effect, probably due to your preoccupation and busy schedule. Towards this end, I would like to convey that at the moment I am actively trying to open both our glass and lamp manufacturing units. And due to my present business compulsions, most of the time I have to stay out of Kolkata, making it difficult for me to keep local contacts in absence for prior intimations. Therefore, in view of such meeting in future, it will be very much helpful for me if the information is sized at least 7 days before the date of meeting, so that I am able to back for the same even I am out of station during that period. Now, as for restart of the unit, I am to state that the machinery is now available in Behala factory are solely for production of GLS lamps, though they had already been refurbished and kept in their working condition. It would not be viable to open the unit depending on GLS production alone, considering the present cost demand scenario of the country. Keeping this in mind, we are embarking on installing an FTL line in the same unit to commence production of FTL and GLS lamps simultaneously to economize the cost of production and optimize marketability for a viable solution of the same. For supply of tuber cells to be used as production input for FTL, we have already procured a second-hand tube drawing machine which is being refurbished and upgraded for a better output. We are also in the process of procuring a suitable FTL machine line for installation at the Behala unit with the target of starting production as early as possible. Apart from above, we have been in touch with a foreign manufacturer for entering into a joint venture agreement to establish an assembly plant in the surplus land of the Behala factory, and thereafter for a full-scale production unit for manufacture of prepaid electronic electricity meters and postpaid meters for marketing in India and other neighboring countries. In a nutshell, the prepaid system, to be the first of its kind in the country, represents an advanced collection system of the process for the supply of electric power to general public and a concrete solution to recover the losses of the electric corporations due to unpaid areas and losses for tampering the meters. These products are very cost effective and user friendly in their truest sense and have sufficient market potential both home and abroad, and is sure to generate finance and employment in keeping with the growth of the unit, provided the much needed supports from the government and the allied bodies are available as and when required. I wish I could discuss the matter in detail and hope to favor with your valued suggestions towards this endeavor. And as soon as I get the opportunity to meet you, I would like to reiterate, it would be very much convenient if I could get your intimation at least 7 days in advance to avoid an information gap and make myself available for this purpose. But this was the, my lord, representation of the petitioners to the authority concerned. In the meantime, my lord, a joint venture, my lord, farm was, my lord, incorporated with a Korean company for the purpose of restarting the, my lord, unit. Now, my lord, this time, my lord, in consideration of that representation, my lord, the authorized the representative authority, my lord, cancel my lease. That is, my lord, at Annexure P4, page 75. What are the grounds? My lord, your lordship will find page 76A, that is a fresh typed copy, man.
Yes.
From N. Datta, officer on special duty technical, to Anup Kumar Shah, promoter, Mrs. Indo Korean Lighting Limited, Ahmedabad, first floor, such and such. Subject, resumption of the properties of erstwhile Mrs. Bharat Electricals Limited, owned by the government on 64/1 Birendra Road, now known as such and such, and leased in favor of the opposite company. Your letter dated June 26, 2006, addressed to the Principal Secretary of the Department. Sir, I am directed to address you on the above subject and to point out the following facts. The physical position of the opposite properties, including land measuring 5.74 acres with the building sets and structures and other movable assets thereon, was formally handed over to you on 27 June 1994 upon considering your offer for utilizing the same for industrial activities. Following this, a formal lease agreement for 999 years was made on 8 November 1996 between you as proprietor of Mrs. Indo Korean Lighting Limited and the government of West Bengal. The term of the lease clearly indicates that at least 120 workers would be employed in the unit in phases in terms of MOU dated 22nd June 1994 entered between you and the ex-workman of VL. According to the lease agreement, you had to pay rupees 140 lakhs towards premium to state government with upfront payment of 30 lakhs. The initial amount was paid to the state government on 7th September 1994. The balance of rupees 110 lakh was to be paid by the government in 48 EMIs from November 1997. In consideration of an, my lord, kindly note it, in consideration of an appeal made by you, the state government as a special consideration allowed that the repayment of the remaining premium of rupees 1.10 crore would be rescheduled to start from January 2000 instead of November 1997. The interest accrued for non-payment of the monthly installment in time till December 1999 was also waived. This was done as a special case considering the fact that litigation by a section of rail employees had delayed the reopening of the works. However, the balance amount of rupees 1.10 crore remains unpaid to this day. But by this letter, the authority concerned admitted that there was, my lord, continuous litigations with the, my lord, petitioners and the, my lord, the workers of the rail.
What prevented you from depositing the balance amount?
But I was, my lord, searching, my lord, to the company for, my lord, entering into a joint venture unit and to start the reproduction. Already I invested, my lord, for restarting process. I already invested at the relevant point of time 2.8 crores. Apart from the 30 lakhs, my lord, I paid.
For your own factory, not to the government.
Yes, my lord. But, my lord, unless I start the production, my lord.
Complied with the terms of the lease.
My lord.
You have not complied with the terms of the lease.
No, that was waived. That was waived.
1.10 crores was not waived.
No. That condition was waived. My lord, it was rescheduled. It was rescheduled. I did not pay in time. My lord, kindly appreciate. I had the opportunity to, my lord, sublet, transfer, assign the leasehold property, and my lord, I could escape myself from the, my lord, all that predicaments.
So neither here nor there. That is no ground.
I had the right. I have the right, my lord.
You have not availed of it. That is no.
My lord,
ground.
no, I had always, my lord, the bona fide intention to restart the production. But, my lord, the predicaments which I faced in starting the, my lord, the unit, or, my lord, because, my lord, it was, my lord, totally dilapidated lying in a very dilapidated condition. My lord, entire thing was to be, my lord, rescheduled and, my lord, reconstructed. For that purposes, my lord, I invested huge amount. My lord, when I appealed before the government that since I am facing these predicaments, give me some breathing time so that I can pay your amount. I have to pay. Unless I pay that, I cannot, my lord, enjoy that property. I know it very well. But on that condition, my lord, this was, my lord, waived.
Breathing time was given to you by the.
My lord, it was waived. Now, my lord, now kindly have a look, my lord, the grounds. Thereafter, my lord, I approached this honorable court. Several, my lord, orders were passed. Your lordship was also, my lord, passed order. I will show that order also. Along with the apostate rescheduling, the government also granted to incentive by way of remission of sale tax, electricity duty, etc. to enable you to reopen the factory. However, you have taken no effective steps to reopen the factory to this. Being aggrieved by this is in action on your part, the Workers' Union of BHEL took up the matter with the government on several occasions. On receipt of their last representation dated April 5, 2005, the situation was reviewed and it was found that you have violated the conditions of the lease between you and the state government by not paying the full amount of 1.10 crores plus interest, and by not reopening the factory to protect the interest of the workers. Clause 5A of the lease agreement provides that in the event of default in payment of any 6-month installment, the interest thereon, as herein agreed, the lease will be liable to forfeiture and the lessor shall be entitled to re-enter the demised premises. My lord, this is the condition for which the lease was cancelled. Now, my lord, I challenge this order by filing a writ petition before this honorable court. Lordship, kindly have a look, page 77, my lord, accept 5, P5.
Yes.
But this is the order passed on 30th March 2010. Both the writ applications, writ applications are there, my lord. Both the writ applications and connected applications are disposed of by this common judgment and order. The writ petitioners were granted a lease of land measuring 5.74 acres with building, sheds and structures and other immovable assets for 999 years.
Please come to the relevant portion.
My lord.
The grant opportunity of hearing was directed to be granted to you.
My lord. My lord, 78. Today, relevant portion, my lord. For 79, my lord. Page 79.
Yes.
When third paragraph from the top, my lord.
Yes.
When at that point of time the state government was desirous of hearing the writ petitioners, and since it is alleged by them that they did not have proper notice of hearing, I think that the Principal Secretary, IR and P Department of Government of West Bengal should give another opportunity of hearing to them. I, however, do not interfere with the subsisting decision of or state of affairs, but only direct the Principal Secretary to give a hearing to the writ petitioners and all other necessary parties and give a reasoned decision within a period of 3 months from the date of communication of this order, whether the decision already taken by the government can be reversed or modified. Lord, in terms of this order, my lord, we represented before the, my lord, before the authority concerned. Now, my lord, page 87, 86, 87, my lord, the order of the concerned authority.
Yes.
Well, 87, my lord, I'm skipping because all these facts have been, my lord, stated. My lord, I'm skipping, my lord, page 87. My lord, third paragraph from the bottom, my lord.
87.
87.
Yes.
Arranging a fresh auction would be time consuming. Since Sri Saha wants to set up a factory on the premises, and since he had spent money on the refurbishing the plant and machinery, it would be more practicable to create a fresh lease in his favor. The following broad decisions are taken The earlier lease which was revoked in 2006 is not being resurrected. This was the decision, my lord. A fresh lease may be executed from a prospective date upon arriving at a fair valuation of land considering industrial use. The terms and condition of the lease will be as usual as per practice followed by WBIDC in case of leasing land for industrial use to the entrepreneurs. In 1996, the total amount of lease premium was rupees 1.440 crores, rupees 80 lakhs for land and rupees 6 lakhs for other assets, out of which a sum of rupees 30 lakhs was paid by the then lessee. The land could be valued by the collector, South 24 Parganas. However, such valuation considering the locality which is completely residential is likely to be much higher than the value the plot could fetch if and use restrictions are imposed. In this case, IR department is agreeable to hand over the land for non-polluting industry only. Thus, current residential valuation cannot be invoked for valuing the land for industrial use. The more rational way to value the industrial plot would be to consider the original valuation of rupees 80 lakhs for the 5.74 acres plot and then arrive at the current value of assessing the opportunity cost of the investment of rupees 80 lakhs made in 1996. WBIDC charges a growth of 13% per year for arriving at valuation of industrial plots. Using the norm and using the base value of industrial plot of rupees 80 lakh for 574 acres and 116 months gap between November 1998 to June 2000, the valuation for 574 acres is calculated to be rupees 271.56 crores as on June 2006. Shah is advised to collect prescribed declaration of intent from the office of WBIDC as required for applying for land and properly for industrial case. A conceptual plan for the proposed industry will be set up in the same premises with milestones and also be required to be submitted by Shah to WBIDC with a copy and IR department. Next, my lord, the final verdict of the authority. Order dated 25th March 2011. Upon taking a review, it is noted that entire land of 5.74 acres as resumed from Indo-Korean Lighting Limited by the government of West Bengal IRD and transferred to WBIDC in June 2006 cannot be reallocated in totality. The ground behind such reconsideration is that a piece of land measuring approx 0.93 acre out of the total quantum of land measuring 6.74 acre had been earmarked the outright sale to one Mrs. Modgul Park by WBIDC through a bidding process after the property was transferred to WBIDC in 2006 by our department. Subsequently, the portion of land could not be, however, be conveyed to the highest bidder, Mrs. Modgul Park Limited, due to some litigations. In the meantime, WBIDC paid 83.7 lakh as gratuity of astral workers of Vale to collectors South 24 for getting them to relinquish their claim on the land. Thus, the right accrued to Mrs. Modgul Park cannot be ignored. Next, my lord, the page 90, other contentions are there. My lord, I'm skipping. Now, my lord, page 90. Land to Modgul Park Private Limited, my lord, out of the land 5.74, my lord, 0.93 acres was, my lord, allotted in favor of Modgul Park Private Limited, which we, my lord, agreed. We agreed. Yes, you give it to Modgul Park Private Limited. And our allotment was curtailed from 5.74 minus 0.93 to 4.91. We agreed. Yes, we are agreed to that. Our land to Indo-Korean Lighting Limited. Indo-Korean Lighting Limited, the erstwhile lessee, that is, and its petitioner is allowed balance portion of land 5.74 minus 0.93 acres, 4.81 acres more or less on a current consideration price for a fresh lease for 99 years by WBIDC on application in format by Indo-Korean Lighting Limited. The terms and conditions of lease will be as per practice followed by WBIDC in case of leasing land for industrial use to entrepreneurs. Considering the reduction in land quantum by 0.93 acres, the net lease premium for remaining 4.8 acres to be transferred to Indo-Korean Lighting Limited is
1.460 crores, we have been assessed more than 200 crores. Now, my lord, the payment which we paid earlier, that was also forfeited. Now, my lord, we challenge this by order before this honorable court.
Chakut, I think we have to continue some other day. I have a meeting from 3.
My lord, my lord, my lord.
1:15. Affidavit of service. Heard learned counsel for the petitioner. Paragraph, let the matter appear under the same heading on 28th September.
And only intelligence, my lord, let the property be remain in the same position, my lord.
No, my lord.
Because, my lord, in the mean, my lord, my lord, I am,
Last order which he challenged, last order, what is the wrong? He must say.
I must say,
Then,
but my lord, in the meantime, my lord, let the status quo be maintained, my lord. I will not use. I will.
Without hearing the parties, I
No,
cannot.
my lord.
My lord, only thing, my lord, then my lord, only that let it be written in the same position, my lord.
Hopefully to retain.
My lord, the property otherwise, my lord, in the meantime, if any, my lord, tender is floated, my lord. Lordship kindly appreciate. My lord, kindly appreciate, my lord, if the any tender is floated, my lord.
Let me see. Come back on the next day, let me see.
But let,
Tender is not floated in a day. It takes some time. So it is not floated as yet.
well,
Come back, let me see, 28th. বলবেন আমার 1:15 থেকে মিটিং আছে, একটা সেকেন্ড হাফে বসতে একটু দেরি হতে পারে আমার। না, দুটোর পরে রাখতে পারি।
সীতা ধরে ওটা তোমার এমনি রুল আবার
Vibrated আছে তো?
My lord, may I be permitted to mention item number 5, with original said matter, my lord. And I had a talk with the other side. Your lordship on the last occasion was pleased to grant me leave to file an application for addition of party. But my application is under process, my lord. Your lordship, my lord, adjourned. I have a talk 28th of this month, maybe fixed, my lord, for appearance. 28th of September.
I have a different mentioning, my lord, against him. That matter that your lordship was hearing, Mr. Ghosh had referred to one particular act in his concluding submissions that was not argued ever before, so we did not.
The one that has been reserved for judgment?
Yes, my lord, that we did not naturally include in the notes. So I've just prepared, I put him on notice, my lord, there's just one-page notes on that applicability of the act.
Yes, Mr. Ghosh.
He can't have, he's argued that at the end of everything. If he wants, I'll give him a copy of the notes. my lord.
Yes. My lord, 28th September, my lord. This matter.
Item number 5.
Oh, 5, item number 5.
List. There's an appellate side matter actually to be taken up before the original side matters are taken up.
There is one.
Huh? It's also- You're asking about item number 5. You need.
I original side, yes, ma'am.
Twelfth October. Yes. ওটা একটা নোট একটা নিয়ে নিন তো আইটেম নাম্বার 5 টা।
এটা কি
12th October নোট রাখো না পরে দিচ্ছি হ্যাঁ। Item number 5, 12th October. Yes, the appellate side matter.
Appellate side, one matter supplementary list, item 1.
লিভ নেওয়া ছিল বলছেন, তোমার ওটা লিভ নেওয়া আছে ওইটাই?
Who is appearing for the respondents?
I am for the WCDC respondents.
Lord, West Bengal Small Industries Development Corporation is the principal respondent. Lord, let me give you lordship the little factual background, Lord. Lord, in 1989, a lease was granted in my favor, Lord, for a plot number K10 and K10/2 in Bihala Industrial Estate. Lord, deed of lease was executed, that I have annexed, possession certificate I have annexed. Lord, on 3rd May 2013, an eviction order was issued under the West Bengal Government Premises Tenancy Regulation Act 1976. Lord, thereafter, Lord, against that eviction notice, ultimately a notice for recovery of possession was issued. I challenged the recovery of possession notice in a writ petition before your lordship's court on the principal ground that this act does not apply and it is not a tenancy governed under this act, so they don't have jurisdiction to evict. Lord, Justice Banerjee, Justice Sanjeev Banerjee, Lord, following a judgment of Justice Tandon, passed an interim order till disposal of the writ petition. Lord, let me take your lordship directly to that first. Lord, kindly straightway come to page 104.
Yes.
Lord, 104 is the order passed in my case. In view of the interim order passed on January 29, 2014 in Malavaskali got it, Lord. I'm so sorry, Lord. Page 104, Lord.
Yes.
In view of the order, interim order passed in January 2014, in similar circumstances in WP number so and so, Sona promoters, the respondents are restrained from taking steps for eviction of the petitioners from the land in question till the disposal of this petition. Affidavit in opposition may be filed within a week, reply thereto, appear fortnight hence. WP 36 along with application therein should appear in the list immediately after WP number so and so. Injunction above will operate unconditionally till March 31, 2014. Thereafter, subject to deposit of a sum of 3.52 lakhs by the petitioner with the managing director of the respondent corporation. Lord, I have deposited that money. I have annexed that. I'll show your lordship. Lord, kindly take page 106, Justice Tandon's judgment, following which Justice Banerjee passed the interim order, because that would be the legal submission from my side. The petitioners have challenged the termination notice dated 9th November 2013 issued by the respondent number 1 under 3(1) of West Bengal Government Premises Tenancy Regulation Act 76 on the ground that the lease deeds were executed in favor of the petitioner in respect of plots of land. While the writ petition is pending before this court, the respondent authority have proceeded to dismiss the appeal, passed an order of eviction. In this application, petitioners have brought to the notice of this court about the issuance of the order of repossession of the disputed plots of land, and a prayer is made for an interim order restraining the authorities from taking any action for eviction. My attention is drawn to the definition of the premises enshrined under this act, which means any building or hut and includes part of the building or hut and a seat in a room let separately, and also includes the garden, grounds and outhouses, if any, appertaining thereto. From the above definition, it leads no ambiguity that anything appertaining to a building or a hut or a part of the building or hut or a seat in a room comes within the definition of the premises. In my view, the words appertaining to have a significance in relation to the letting out of the building or a hut or a part of a building or a hut or a seat in a room. The dominant purpose of letting out is in respect of a building or a part of a building, and if the garden or the grounds are also let out simultaneously, which appertains to the primary letting out in the squarely comes within the definition of the premises. Therefore, the letting out of a garden or a ground or outhouse alone, in my view, cannot come within the definition of premises unless it is appertaining to the building or to the part of the building or a seat in a room. Lord, kindly pause here for a moment. I have annexed the lease deed. I'll show you lordship the schedule. It's a land. Once it comes with a building, it will come within the purview of this act. The respondents rely upon a judgment of the apex court in the case of Swanso, reported in year 2007 Supreme Court 788 in support of the contention that the word includes can give a wider interpretation. It is further submitted that the apex court in the above report have interpreted the word any to include the premises let out for commercial, industrial, reception as a purpose. Therefore, any restricted meaning to the word premises would be opposed to the legislative intent. In my view, the issue involved in the writ petition relates to the applicability of West Bengal Government Premises Act 76 in respect of the lease executed by the government for plots of land without any structure thereupon. Therefore, this court does not find that the judgment of the apex court as relied upon by the respondents has any manner of applicability in the present case. This court therefore finds that a prima facie case has been made out by the petitioner and the balance of convenience, inconvenience granting, considering the same respondent restrained from taking any steps. So this was the legal background, legal issues on which interim order was granted in my matter. Lord, I deposited that amount. Let me show your lordship. Lord, your lordship kindly take, Lord, 109 kindly take for a second.
Yes.
I have deposited the money in terms of Justice Banerjee's order. The check is annexed to the letter at page 1010 that has been encased by them. Now, Lord, what happens? Kindly, Lord, now 13 years, 14 years in the meantime passes. In 2023, my writ petition gets dismissed. They never made any attempt to get the writ petition heard. Interim order was there till disposal.
Their writ petition, we shall take space for. You are the petitioner in that.
Here, their writ petition, their intention is
No responsibility whatsoever. Yes, next.
I was enjoying an interim order. They filed their opposition. If they were agreed by,
It's not,
Lord, the matter, I did not say that. Matters were all along in the list. It was pending department. But what I am saying is the respondents, if they were agreed by the interim order, they could have preferred an appeal, or they could have pressed for the hearing of the writ petition or filed a vacating application.
your own case, sir.
They never did that.
Not rely upon the weakness of the.
My lord, definitely. Not my case. I have shown your lordship what was my case. Now, what happened thereafter? In 2023, my writ petition gets dismissed for default, page 151. Kindly comes.
150?
151.
Yes. This is a recent dismissal.
Yes, 2023. So I enjoyed the interim order from 13 till 23, 10 years. Nothing has been done by them. So they were not agreed for 10 years with this. What I'm trying to impress upon your lordship is, now, Lord, in between why this dismissal had taken place, kindly come to 147 for a second. Lord, I was diagnosed with cancer. So I could not, my lord, take steps in court. Kindly take page 147, the proprietor of the concern.
For restoration?
Lord, I got to know from their notice. আপনি তাহলে বলে নিন যদি
না, না,
আপনি
extra আমি যেটা বলছি
Please
তাই।
allow me to finish the matter. What is this? You allow me to address the court.
চল, আমি শুধু
Lord, I got a notice from them. After this dismissal, what happened is, Lord, they served a notice of eviction at page 152 in July 2023. Kindly comes. 151 is the order of dismissal. I was suffering from cancer, page 150.
147 is after the dismissal.
Yes, my lord, that is
A
the,
document showing you.
that's the recent document that I have annexed. Page 147, kindly see at the top of the date, assessment date 17 July 2023.
After the cancer.
Yes, no, cancer, my lord, someone doesn't suffer cancer on a day, and the matter was dismissed in 21st June 2023. So I have annexed documents in the month of July. So, my lord, after the dismissal, if I'm suffering from cancer, my lord, I could not approach my lawyer and come to court. That is what I'm trying to show your lordship, that I was not sitting idle.
Not on the dismissal, it's a separate.
Yes, now page 152, they issues a fresh notice of eviction.
Page?
152,
Yes.
after the dismissal. Now, this notice of eviction and the notice of eviction, which is at page 87, are almost similar. Almost similar. And in between, they have accepted that 3.5 lakhs, which I have deposited in terms of Justice Banerjee's order. So taking advantage of the order of dismissal, they issues this. Lord, apropos to this, I sent them a reply. Kindly, my lord, take page 154.
Yes.
Lord, why I am showing this to your lordship, my lord, I could have, my lord, shortened my submission, informing your lordships what they have done after filing of today's writ petition. I could have said that what they have done today. I took leave at 10:30. I informed them. I personally from my mobile WhatsApp the fact that I have mentioned your lordship granted leave to the law officer. I informed my learned senior friend on the other side. We served the notice on them by mail, by hand at 12. At 1 p.m., despite knowing that your lordship has fixed the matter at 2 p.m., they went there and took over possession. Lord, 10 years they could have waited, but 1 hour they could not wait. At least they could have waited for the court to decide the matter. This undue haste.
Now.
Yes. Now, my lord, 25th
Under
July,
these changed circumstances, what are you seeking?
Lord, I would be seeking, my lord, recovery of possession. Because when I approached your lordship's court, my lord, what happened thereafter?
No interim order is required at the moment.
Interim order, what is required is, my lord, restraining them from allotting the shop to someone else. Let status quo be maintained. The lordship call for a record from them. What was the impending urgency that despite knowing that the matter has been filed, your lordship granted leave? What was the impending urgency for them not to wait for even 1 hour and take possession at 1 p.m.? Lord, your lordships, my lord may allow my prayer, my lord may not allow my prayer. That is for your lordships to decide. I am here with a case to inform that legally I have this case. My lord may reject it. It is up to your lordships. But the respondent cannot take advantage of this fact. But I have never come across this sort of a thing that after the court grants leave, after we inform the respondents, they will, to overreach the authority of the court, to take things away from the court, they will go and take possession. Lord, this is something, Lord, unheard of.
For the moment, that's all your submission.
Lord, for the moment, I prayed for, Lord, stay of the entire thing, but they have taken possession.
Let me hear Mr. Chatterjee on this issue.
And I challenge page 178. That was, my lord, I have shown your lordships page 178 and, my lord, page 179. 179, my lord, is the notice issued on 11th. What I received on 12th. My lord, today, kindly appreciates one thing. I succeeded before one honorable judge.
Challenge the 178 notice, order.
178, 179, 152, all three.
178?
152, 178, 179. The eviction order, eviction notice, and the notice for police help, everything. Lord, may I show your lordships the definition and the lease for a second, which I have shown to Justice Banerjee. Kindly have a look at this, just to show the prima facie case that I have. Kindly see the definition, section 3C.
This has been decided in the earlier orders.
Yes,
Coordinate them.
so if the issue is of jurisdiction, they should have been more careful. They should have waited. Since I have challenged their very authority to do that. Lord, kindly appreciates today, if, my lord, they have taken position, they allot it to third party. If ultimately your lordship holds that they never had the authority to do it, who will compensate my loss? Lord, I would say that my lord will direct them to, my lord, return back possession. Your lordship will decide the matter. Then if they are entitled, they will evict.
Position can be done only upon affidavits, not before that. For the time being, let us see what relief can be granted. Yes, Mr. Jackson.
My lord, in this matter, a lease was given, plot was given to them in 1989. The lease expired in 1998. The rent was 1,103.60, but a subsidized rate, it is 2,079 square foot.
There was an interim order of the court.
No, my lord, you have to kindly see.
Yes,
Interim order was the court, at that time, the dues was there, court has said you pay some dues, and
that was paid.
that has been paid, my lord, thereafter, that's going on. My lord, presently, my lord, I'm saying presently, my lord, the dues is, they are enjoying the property. The dues is 5,50,201. This is the chart, but you'll kindly see, this is the chart. Now, after it was dismissed on 23rd June 2023. Now you'll kindly come to page 176. We have not done at rest. You also kindly see the first, the dues is there. Well, kindly see the dues.
176.
176,
Yes.
Well, you'll also kindly see after dismissal, we issued them a notice on 28 August 2023. Call for a hearing. Well, not only that, before that, we granted him 36 installments to pay the amount. Yes, they have not paid. Now, after dismissal of the writ petition, we asked them to come for a hearing. But hearing was given, they attend, my lord, nothing, but they didn't pay anything about that. Now, my lord, resumption order was thereafter passed. My lord, if they say that we are taking at haste after filing the writ petition, we took possession, it is not that. After hearing, 177 order was passed in 1st of September. Well,
The fact that you have taken possession today.
Today at 11 a.m. You'll also kindly see it was written there.
At 1 p.m.
No.
Not 11 a.m.
No. At 11 a.m. you should kindly see. At 11 a.m. It was fixed for 11 a.m.
Let the matter be heard on
Now, my
affidavits.
lord, first thing is this, you see,
Because your authority of it to evict.
they will have
is
to
challenged.
pay the rent. They will enjoy the property of the government land. They will enjoy it.
You
They
have
will have
taken possession today.
taken possession today.
Yes.
My lord, land will be.
The petitioners are out of position from today. Let the matter be heard on affidavits. In the meantime, please do not create any third.
Now,
party
Lord, kindly
interest.
consider. Now, if the government land, so many industries are, it is small scale industries, limited land. We are giving the land to the small scale entrepreneurs to use the land. But if they don't deposit the rent, they will.
Let
Stop.
me just. be
Lord,
clear.
by Monday, I will deposit 5,50,000.
They will just go. Yes.
Let them return.
No,
let
we
them-
can't. It status quo we maintain after illogically hear the matter.
But then,
Respect of nature, character and.
Lord,
possession
then if I
as of
don't get back
as a
possession, then what is for like?
Lord, it is there. He enjoyed the
Lord,
property.
Possession
May-
will be
may
only
I-
upon merit.
May I say this, my lord? I'm a running concern. I will deposit the money on Monday before your lordships. Keep it on Monday. Let them return possession. Your lordship decides the matter.
Possession cannot be returned like this, you are aware.
After you also can hear the
If they
matter
have
within 10
taken
days.
it illegally, then your lordship has all the power to decide. My lord,
If they've taken illegally, they'll return also illegally.
no, I'm not saying that. Your lordship will direct them to return.
Return of possession at the moment will be illegal because the matter is being adjudicated by this court.
Very well, I'll answer to the affidavits. Call
Exchange
for a
your
short report.
affidavits,
Call for a short
deposit
report.
the amount by
Yes, I
Monday.
will get.
Lord, I will not get possession again. I'll deposit the amount. Lord,
But we
kindly
have already enjoyed
see
that.
my balance also, my situation also.
Not a post facto deposit, sir. This is the deposit for which you have enjoyed already.
But for that, let them return me the possession. Lord, to show my bona fide.
Till date.
Lord, to show my bona fide, I'll deposit whatever amounts they want. Even in my reply to the eviction notice.
Return if you succeed in the case only, not before that. An interim order can be passed only if you deposit this amount. Not before that. Because this calculation is till the day you have utilized the property. Not from today. Isn't it? It's in the retrospect.
Early hearing kore dao na.
But I have nothing to say. Lord, I leave it to you.
7 days, 10 days I shall file affidavit.
Lord, with greatest of respect, I don't think, my lord, if some response in my blood, kindly don't take me amiss, in my humble understanding of law, if something is done to overreach the authority of the court, if the court has
But
all the
1
power.
PM he rang me. Well, I say that I can't accept the
No,
writ
no, no.
petition. You
Lord,
change.
I have never spoken against him. I
The
re-
document says 11 AM. You say that you have communicated at 1 PM.
No, no. Kind of 10:50, I have communicated to the legal officer. This is the WhatsApp written. There's a blue tick.
WhatsApp it is
He has seen
possible.
it.
I told
He
them
has seen it.
immediately
Lord,
serve them.
from my court,
They will,
Lord,
if they ask me to appear, I shall appear.
these are not our personal matter. I have never said anything against him personally. I called him, I requested him. He said, I cannot appear. Now he is appearing.
Now,
I have been instructed now.
This is not the right thing.
Mr. Dales, to
This is not right.
Petitioner has any bona fide intention. If he has a bona fide intention, he can file one application for restoration of the order. If that is done, my lord, it will be restored automatically.
I'll do that.
This court order.
I'll do that.
That was not done. But without giving that, he filed an application. There, after that, my lord, that order was passed. His intention is not a very good intention, my lord. And now he filed this application.
do you concede to the order that have said the petitioner will deposit this amount within 7 days?
I am not, my lord, that is my learned.
That is your lordship.
And let the matter be
I am
decided
at
on
a state, my
affidavits.
lord.
Yes,
That is,
Because these issues should be taken into consideration.
yes,
I'm grateful to you, lordship.
Lord, I have only one.
Had a good case, but the petitioner has spoiled the case himself.
yes, ma'am.
That, Lord, I also agree with that.
Kalidash is Nijer Pai Nije Kurul Hai.
Absolutely.
You've done
Lord,
that.
what I submit before your lordship is, উনি কোর্টে আছেন, জিজ্ঞাসা করো এটা, ask him whether this is the due. Lord, without prejudice to my rights, I will deposit that amount. What I beseech before your lordship is, today they have taken the possession. Lord, kindly hear me for 1 minute only on this point. At 10:30 I moved. At 11 he says it has been taken. So whatever has been, আমি তোমার কথাই বলছি, whatever has been done today. So today they have taken possession. Till yesterday the due is there. So if I had paid this money yesterday, they wouldn't have taken the possession.
167.
So I will pay by Monday. After I pay, let them return it. But they will not suffer any prejudice. Then if I lose, they will take it back again. Lord, they will take it back again.
176.
Admittedly expired, long
Lord,
back. Lease has admittedly expired.
But
long
if they
back.
do not have any right to evict me under this act, then entire proceeding is bad.
That's what I said, come back on affidavits. If you have a good case, you win, sir.
Lord, hearing matters before vacation, I am sure it will not.
It will be difficult. I should be very
Then,
candid.
Lord, consider my plight. A running concern is being closed by like this. I am paying the money. Let them return back.
Now they are paying the money. They
Lord,
could have
let
paid
them,
earlier.
Lord, what I say, let them return back without creating any equity. I'll use it. Whenever your lordship decide, I'll vacate.
Come back with a supplementary affidavit also. Because during pendency, this has happened.
Yes, I'll come back on Monday. Keep it on Monday. I'll come back with the draft and the supplementary affidavit. Lord, kindly appreciates, I pay, I am a running concern. Then I pay, I don't enjoy. Before pujas, then what will happen? Lord, I'm paying them. Let them return it to me
Well, the
without
huge
claiming
amount
any
they are,
equity.
they're paying on compulsion. Last
But
long
can you
years they have
support
not
your-
paid.
Can you?
If they pay the amount,
Yes,
is it
yes.
feasible for you
Yes.
to return the land to them?
But I cannot say anything. My lord, the already possession has been taken. It's a government property. I cannot say anything. My lord.
Illegally, you take possession.
Not illegally.
Lord,
But they
kindly-
could have filed the writ petition even after when the hearing was given, when the hearing he was disallowed, he waited. He waited.
You could have,
Till the date.
you could have
First-
extended your hand when you got to know.
First
that my
September,
lord has fixed it
the
at 2
resumption
PM.
order was served upon him.
There are lapses on the part of. both
Today is
Yes.
14.
I am ready to deposit the money. I am ready to deposit the money.
For this day to.
Yes, absolutely, my lord. I completely bow down. A cancer patient, I am depositing the money. Let them return it. Let me use without creating any equity. If I lose in the writ petition, I will hand it over.
How we can.
The client is here in court.
That is not the point.
The client is present in court.
No, maybe, but the question is this, he was waiting till 28th of August.
But you could have
He could
waited for
filed a
1
writ
hour.
petition At that time,
But if
he
they
could
had
have
waited
filed a
for
petition
1
even
hour,
on
this would not have arisen.
First September, he has not done.
The petitioner is at fault. They have not asked, prayed for restoration of the earlier writ petition.
And not paid the money, not paid the money.
Paid the money, all that is all right, but
If restore, my lord, then it is automatically.
will you please speak to your client as to
Yes.
whether it can be given back to
Exactly.
him without any equity?
Yes.
Lord, I say kindly keep it on, let them deposit on Monday. I
Yes.
shall talk with them without passing any order. I shall come back on next Thursday. Because the
So then you
concerned
pass
officer,
any order at the moment?
no, you should kindly pass an order for depositing the amount, otherwise it will have.
Your
Hey,
lord, today,
No.
today your lordship passes an order directing them to maintain status quo so that.
No, but
they
that
don't-
is not, firstly deposit
কি
the amount.
আশ্চর্য, আপনি কাউকে দিয়ে দিলে কি হবে?
আরে
আরে
আমার
আমার
দিতে গেলে I have stated
At the bar,
My lord,
at the bar, he says he'll come back next Thursday.
Next
not
Thursday.
Next Friday.
Lord,
Thursday is original.
tomorrow if it is,
Time of the
Lord,
original
tomorrow if it is allotted to someone else, kindly restrain them from allotting it to someone else. That much of injunction I can expect. Yes.
create any
Well, Lord,
thought.
your lordship, kindly, problem is this, well, what
Now
I'm
this
saying.
is-
Problem is this, but if the matter is not being heard, the land is being unutilized, land is very limited. But the industry, long queue are there.
Yeah.
They have been running a business which has been
Yes.
suddenly stopped.
Yes.
You say land unutilized, so both the parties
Then-
have to suffer when the
then-
restrictions
My lord,
started.
they should have.
Grateful to your lordship. 5.5 lakh টাকা
Third learned counsels for the parties.
Your lordship, kindly fix the matter for hearing on Thursday.
No, no, Monday has to be mentioned for depositing the money.
Two minutes and তুমি deposit করে দাও না, or as per today's
Very well,
order.
they will come back with instruction on Thursday.
Thursday, yes, I shall come back with instruction on Thursday. আমি যদি
My
পারি
lord,
করে দেবো,
direct
আমি যদি
me
পারি করে দেবো।
without prejudice to deposit the entire claim amount.
Listen to the order, I'm passing.
I
the
shall,
order
আমি
to you.
পারি যদি করে দেবো, কিন্তু আমার উপর চাপ দিলেই পারবো না।
তোমার উপর চাপ দেওয়ার ক্ষমতা কারোর আছে?
কিন্তু এরকম বলুন।
কি বলছো?
It is contended on behalf of
না,
the
18 নয় হয়ে
petitioners
গেছে।
that petitioners were granted lease in respect of the plot in question by the government of West Bengal
But by the West Bengal Small Industries Development Corporation Limited, not the West Bengal government.
by the West Bengal Small Industries Development Corporation Limited. On
Lord, Lord, may I take your lordship leave for a minute? Mr. Mondal is here, my lord.
on 8th June 1989, the lease, a V-Day deed of lease dated 8th June 1989.
সব চলে যাচ্ছেন, আমি একা ফেলে দিয়ে যাচ্ছেন, আমারও মামলা আছে, 40 নম্বরের মামলা চলছে আমার।
তুমি যদি affidavit report করবে না,
And
দেরি হয়ে যাবে।
the term of the lease was extended from time to time. Stop.
Or lease was not extended, my lord. They continued in possession.
They continued in position.
A lease was not
They
extended.
took rent also.
They continued in possession.
Page 6, paragraph G.
Well, I don't have to copy the petition, my lord. They continued in possession.
It's the contention of the petitioners, I record.
Well, my sort of আমি জানি, কিন্তু আমি তো পড়তে সময় পাইনি ভাই। আগের গুলো আগের থেকে বলছি। Well, so kindly, that paragraph, so kindly, it is lease expert.
Petitioners are in possession, the petitioners were in possession of the property till date.
As per the interim order, they are in
There
possession.
is the earlier notice which was challenged in the earlier writ petition.
My lord, the eviction notice was
3rd May
3rd
2013.
Is as page number 87, my lord.
87.
87.
An eviction notice was issued upon the petitioners by the corporation on 3rd May 2013, which was assailed by the petitioners in a writ petition being WP number 4280 within bracket W. Please,
Madam,
correct me if I go wrong in the.
My lord, my lord, my lord, my lord, my lord.
Of 2014, stop, by an order passed on 25th March 2014, comma, a coordinate bench of this court directed the corporation, restrained the corporation from taking steps for eviction of the petitioners from the land in question till disposal of the writ petition. Stop. The court further directed that the injunction would operate unconditionally till March 31, 2014, and thereafter, subject to deposit of a sum of rupees 3.52 lakhs by the petitioners with the managing director of the respondent corporation. Stop. The said amount was admittedly deposited by the petitioners
On 28th March, page number 109, my lord.
on 28th March 2014. The writ petition was dismissed for default by an order passed on 21st June 2023.
23rd, no?
Following which
23rd June.
21st June, 21st June,
21st June.
21st June 2023, following which a fresh notice was issued upon the petitioners akin to the earlier notice, AKIN, akin to the earlier notice, directing them to deliver vacant possession of the premises within 30 days thereof. An order was passed by the authority on 1st September 2023
Well, before that, my lord, page 176, hearing was given. Page 176.
The petitioners were called for a hearing by the authority on
Hearing held on 31st August.
31st August. On 31st August 2023, following which an order was issued authorizing the SAE in charge of Behala Industrial Park / Estate to issue notice confirming the date and time of resumption in consultation with police administration. The date of eviction and resumption of the premises was fixed today, that is, on 14th September 2023 at 11 a.m. Paragraph. Learned counsel for the petitioner submits that notice of the present writ petition challenging the authority of the corporation to serve such notice of eviction upon the petitioners has been, it is informed bola, sentence ta ki bola mujhe? Submits that was served, has been taken, was served upon the corporation this day, despite which the petitioners have been evicted from the premises at about
My instruction is at about 1 p.m.
Madam, my instruction is 11:30.
at this day. Stop. Let us not go into 11:30 and 1. Paragraph. Learned counsel for the corporation submits that the resumption was carried out in terms of the notice dated 11th September 2023
No, 1st September 2023.
and
Yes, 11.
the dues of the petitioners as on 1st March 2023 is to the tune of rupees 5,50,201. Paragraph. The petitioners agree to deposit the said amount by Monday,
My lord.
by Monday, that is.
And that is 18th, my lord. 18th September.
18th September 2023.
My lord, one indulgence without any prejudice to my right and contention.
Paragraph. the amount of rupees 5,50,22,000 in view of the same, in view of the same, the amount of rupees 5,50,201 be deposited by the petitioners before the corporation without prejudice to their rights and contentions. Deposited before the corporation and received by the latter without prejudice to the corporation and received by the latter without prejudice to the rights and contentions of both the parties.
Both the parties.
Paragraph learned counsel for the petitioners further submits that since the petitioners are agreeable to deposit the amount due to the corporation, the corporation be directed to deliver possession of the plot in question in their favor, since they have been carrying on business therein regularly. Paragraph learned counsel for the corporation seeks to take instructions in this regard.
Fix the matter on Thursday.
Paragraph let the matter appear under the heading to be mentioned
My lord.
on Thursday's original side.
As you know,
Come
whenever
back on
you're
Friday.
Friday, well, I have another matter. On Wednesday,
To be mentioned will be in the morning, so fine. no
Friday,
problem.
Thursday.
At least my lord, till then a status quo be maintained, my lord.
Yes, yes.
lord.
Thursday is 21st.
My lord, till then at least status.
21st September, paragraph. The corporation is restrained from creating any third-party interest in respect of the property in question till the adjourned date.
Till that date.
Please try and convince your client. The matter may go on since your authority has been challenged.
But that judgment has gone to the Supreme Court. Supreme Court has upheld that Justice Tandon, the judgment they have referred. Sona promoter.
Please come back with the
Sona
judgment on the
promoters.
next day.
I shall try to.
Yes, original side. I'm sorry, I've cut short the original side time.
Original side, item number 1. I need not trouble, my lord. This is a case, my lord, where your lordships have already held, my lord. The permit holder, but the permit has been expired long back 13 years. Normally, our contention is that it has to be declared vacancy there. It is an interstate route. One cannot, the life which is up, the expiry, did not leave at all. So let there be. They have to take a decision on that issue, and they already taken a decision. So for my knowledge, goes last occasions. And yes, that has been expired and that permit has been already cancelled. Only thing is pending. Yes, in the last one.
Vacancy declared.
Let them.
After vacancy declared, you will have.
Yes. No. Why should I again apply? The applications is there.
Who the application হবে না?
Why not?
No.
No. The permit has been expired long back in 13 years back. Now my application is rejected on what ground? There is no vacancy.
Yeah.
How can it be? Because the permit has been. My lord, that cannot be. Again, why should I apply? So what is the reason? My lord, this then I shall place my lord a judgment there.
It was rejected only on the ground of no vacancy.
Yes.
So now the vacancy is there, so his
No,
application
vacancy is not the vacancy declared. Now.
But then I shall place that judgment. My lord, 2 judgments are there. My lord. Coordinate bench judgment. They are my lord, the applications made in 14. There, my lord, their applications made in 2014. That applications pending long back. They are declaring that there is no vacancy. Now it appears that the permit has been expired. I shall produce 2 judgments. One is my lord Justice Doctor's judgment, and another is my lord the very recent judgment. But following that judgment, my lord Justice Moshumi Bhattacharya. But 2 judgments are there, my lord. On that basis, my lord, the earlier applications,
Please
the
come back
application.
with the judge, because my lord,
Then I shall.
The vacancy has been made.
And there, my lord,
Now vacancy will be published. in the public domain, otherwise the,
I will the
then my lord,
petitioner-
again, third party come and say the, no.
No.
Interstate.
Then I shall place my two judgments here and they have, that judgment has been complied with my two judgments. In respect of one, my lord, the interstate,
Come back with the judgment.
my lord, then,
Yes, let it be
I will
adjourned.
not.
Take my instruction also.
You want to take it back?
No, Lord.
Let it be on record. Instructions submitted. Sabdan. Instructions submitted on behalf of the state respondents is taken on record. Paragraph. On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on
Justice Dr. Judge.
next Thursday, 21st,
Mal.
21st September. Next,
Item number two. Item number two.
এরকম কিছু আছে কোনো ইনস্ট্রাকশনের ব্যাপার ছিল
petitioner,
well I'm for the petition the issue involved means nothing the petition is a permanent was a permanent permit holder. He surrendered his permit and he made an application for a fresh permit in another route. The applications were allowed, offer letter issued. He placed all these vehicles and other documents.
permit
the-
is not issued.
Permit not issued. On the contrary, they send a notice that even if I surrender the vehicle, unless I get the no objection certificate of the financer, they will not get the surrender. Now that cannot be because I surrendered the permit. Now what is the there is no law, so I have to place a no objection certificate from the financer with whom that vehicle which has been under hire purchase agreement. Now, there is no law favoring. They are asking.
Placed a new vehicle.
No, that vehicle I already applied for grant of permit with grant of new permit with that vehicle.
The same vehicle.
Same vehicle. Now they are
But
asking
you asked for different route.
in a different route. They have issued the offer letter. I submitted all documents along with that vehicle. Now they are asking a no objection to get the surrender certified that I have to surrender permit on the basis of the no objection granted by your lordship kindly see.
Is there a report from the
কোথায়
state?
সেটা কোথায় তুমি যেটা বলছো মুখে সেটা
Where did
কোথায়
the state say this? Is there a report?
Yes.
কোথায়
Paragraph 16, sorry, page 16, paragraph 5, annexure P5.
page 16 annexure P5 এটা কি আছে
Several traffic cases in that.
That I have given, that has been paid. কোথায় বলতো?
Where is the document?
That is on page 16. Sorry, this should be the page 17. Page 17, P6. That have annexed all the documents that I have paid, the voucher, the challans and already paid. So that part apart, your lordship kindly see surrender pending due to no NOC from the financer. But I'm only on that part. A permit holder going to surrender the permit not to operate, they are also the authority in which law?
Mr. Sen? Where is the provision?
My lord, I have to look into this matter
Please
afresh,
take instructions.
my lord, because
Because-
one thing is clear that so long my lord, the financiers' dues are not paid under the hire purchase agreement, my lord, the registered owner is the bailey. The main owner, practically, my lord, the financier. He can take away the vehicle for non-payment of the installments. He is not my lord, the purchaser, as if, my lord, if somebody purchased the vehicle without any financial assistance, because on the, my lord, the registering document, there is an endorsement that it is hypothecated with some financier, either bank or private. Now, the permit is attached against a vehicle, or the vehicle is attached with the permit. Now he says that after obtaining the permit, now he want to surrender the said permit. So vehicle is to be released from that particular obligation to ply on the said area or route. Why it is done? That means the financier, he has to say something. So she kindly consider,
because he has purchased the vehicle from the, my lord, the finance that has been, my lord, created or finance made by the
And
financier.
it was flying in a particular route.
It was flying in a particular route.
He only wants a change of the route.
He wants to not change, my lord. First of all, if he wants to fly the vehicle on other route by way of a fresh permit, my lord, he has to apply afresh in that route that he has done this.
He has applied. yes.
Then offer letter issued, that has been done. So up to this stage, there is no problem. Then he has to place a vehicle that's a free vehicle. According to Motor Vehicle Act and the rules, it is stated, my lord, that he has to place a vehicle, a free vehicle. He has to place the free vehicle within a certain period, as it is mentioned in Rule 141.
You say it cannot be a hypothecated vehicle.
I'm not on that. First of all,
What does this free vehicle mean?
free vehicle means not hypothecated. Free vehicle means the vehicle which is not attached with any permit.
It is
The vehicle
placed.
which is not attached with any
Because
permit.
it's placed.
Here, no, that has not been placed. Here, what he phrased, he placed the vehicle along with the permit with a rider or request that please accept the surrender of the permit. That means cancellation of the permit.
Yes.
Cancellation of the permit. So, first of all, the cancellation of the permit, then according to authority, there are two impediments as it appear from this letter. First of all, the NOC of the, my lord, the financier, whether that is right or wrong, I shall take some
The
instruction.
provision for it.
Yes. Now, the second part is that, my lord, there are several traffic cases.
That has been cleared.
Now, unless and until at least those traffic cases, he has to, my lord, meet these. He has to solve these
It is
traffic
made-
cases.
It is made the next page.
If that is so, then that problem is over.
So the only part is that
Now,
NOC.
only part is NOC,
So please take instructions. and-
my lord. Or my lord can also, my lord, think these two applications are separate. One is for surrendering the permit and you take a call at least. That decision has not yet been taken. Thereafter, my lord, the issuance of permit comes. So let, my lord, matter be, my lord, because they have not yet taken any decision. Let them take a decision. This is the only authority, the one window, the state transport authority.
Negative, they'll say that NOC is not filed. So we do not allow. Because they are waiting for an NOC. So the court has to take a decision.
And my lord, simultaneously,
No,
rightly says, unless a vehicle is free from any other permit, they will not grant the permit. That permit.
Naturally.
Yes, then
Has to be
they
done
ask me the
after
NOC.
First the surrender, then the permit,
First the surrender,
then the permit.
then they have to take a call on the basis of that. And then my lord, the permit. So, my lord, may I tell lordship, my lord can, my lord, direct the particular, my lord, the authority to consider this aspect, my lord, conjointly.
They have already considered, Mr. Sen. They have considered and they have said that an NOC is required. So unless the court holds that NOC is not required, there is no provision for an NOC, the authority will pass the same order, a negative order.
Very good, my lord. Yes.
Isn't
My
it? Authority will again say there is no NOC, so no surrender is possible.
My lord.
They've already made a decision, they've taken a decision already.
Look, yes. Another thing is, my lord, though I am not on that, my lord, the pressing that, but it should be that the, my lord, the financier, that is the, my lord, the main owner of the vehicle should be made a party hearing.
Where is the provision for it? How is the main owner involved? It is not a new vehicle. It is already under hypothecation. It was running in a particular route. He needs a surrender of the earlier route's permit and a fresh permit for a new route.
Very good, my lord. Then I shall take instruction on
Please
this.
come back.
My lord, whether there is any GO or any,
Yes,
because there is
yes.
no rules that I
There
know.
should be some provision.
But if there is some provision, then
So
I can
call
place.
for an NOC. Yes,
My lord. If there is no, then my lord can instruct it.
yes.
My lord.
The letter issued by the Regional Transport Authority on 18 July 2023 is assailed in the writ petition. Paragraph, learned counsel for the petitioner submits that there is no provision for
না না ওই এটা জানতে হবে
obtaining
আমাদেরকে
no objection
particular
certificate from the financer for surrender of a permit before the authority.
একবার বিকেলে এসো একটা ফোন করি ওদেরকে
A paragraph, learned counsel for the respondents seeks to take instructions in this matter. Paragraph, let the matter appear under the same heading on next Thursday,
নেক্সট থার্সডে
21st September. না, আরেকটা further instructions করে দিন তাহলে। Further instruction, ওই একই জিনিস কি দেওয়া আছে? ও, তাহলে কি ঠিক, তাহলে দরকার নেই।
ও বসিয়ে দেবো
Number 3. This matter, your lordship, I know, I will not take the time even. Because the issue, this issue is that this section 69, subsection 2. Where the portion of the route covers the only today my learned friend has to take a instruction from the authority. That's only. Whether
A report was called for.
yes,
Identical matter.
yes, lordship, that those two matters are pending.
6 October 6. She doesn't take for it.
Report next document.
Then yes. I think 6 October, the other two matters already your lordship.
Oh, when? 6th October.
Yes.
That I think 6
6th
October is
a Friday.
the appellate side day.
Friday.
Yes, that was in the appellate side matters, That's why your lordship fixed it.
So the decisions there will cover this also.
So it can be the next Thursday.
That is 30.
So that also this also cover the other two which will be coming up.
Either
Either
way,
way,
yes.
that's why
So
any day, because
5th October is a Thursday. Let it be on 5th October. 5th October.
5th October. But
এটাতে 3 তে নিয়ে নিন।
6th is
Report in the form of affidavit.
12 day হয়ে যায়। let it be 12th
but
October.
that is
Because
on the
after
verge of the vacation. We are going. Let it be 6.
আর ডিসিশন হয়ে গেলে 6 October হয়ে geli to হয়ে গেল।
Let it be
A
5th.
report in the form of affidavit submitted on behalf of the respondents is taken on record.
May I take leave,
Where is the report? দিয়েছেন? আছে ওখানে?
আমি একটু দিলাম।
লেখা নেই তো কোথায়? দেখো তো এটা। Okay. Paragraph, by consent of the parties, let the matter appear under the same heading on 5th October, Mr. Devra.
Well,
Yes.
instead of 5th one, that is the 12th, that will better. There are two matter, two or
Yes.
three matter. 11th one.
Only it is either with the same thing. 5th will be, it's
Either-
earlier. It will be earlier a little bit.
Wait, the others are on 6th, so come back on 12th, we'll decide.
That is
as you know.
covered by the
12th October.
developed by the.
হ্যাঁ, হ্যাঁ। Private কি বলেছিলেন না? Date of-
Section দিবি, হ্যাঁ? বলে দে তাহলে exception.
Well, exception if any in the meantime, we shall. Exception if any, we shall serve in the meantime.
এর আগেরটাতে, on prayer of the petitioner, liberty is granted to use an exception to the report, comma, if necessary.
Fine. Developed.
Anyone appearing in item number 5, I had adjourned the matter.
Yes. Lordship,
But in item number 5, my lord, I am appearing on behalf of the state respondent, my lord. I would have made the prayer for an adjournment because I was being led by Miss Noel Banerjee in this matter, my lord, due to some personal difficulty. She couldn't attend to court today, my lord. So that's what I was making the prayer.
Nobody is there. Lordship, earlier nobody was there. Lordship appoint me.
No, my lord, on the last occasion, Miss Banerjee had argued the matter, my lord.
Anyway,
That was on the 1st of September, my lord.
Difficulty is when the matters are called, you do not appear, I appoint someone and then you turn up and say that.
My lord,
14th
fixed.
12 fixed.
12 কবে? 12 October.
12 October.
Mr. Siddiqui and Mr. Debroy. What is your Miss Banerjee is appearing, you say?
She is my senior. She is leading me in this matter, my lord. Miss Noel Banerjee.
Did not appear on the earlier date. You have given the name. I have requested Mr. Debra and his junior to appear. Since there was no representation. How can you appear like this, sir? I do not know.
My lord, we had been engaged officially, my lord. We had received the brief, my lord, when the matter was called on for the first time. Then on the next occasion, when the matter appeared,
What happened in the first occasion?
my lord, at that time, my lord, we did
For the
not.
court also.
My lord,
Appointing someone.
I apologize, my lord, because at that time we had not received any instruction from the concerned department, my lord.
Brief, right?
My lord,
Anyone for the petitioner? On prayer of the state respondent?
Yes, no. One petitioner already mentioned on the mentioning time, Mr. Ghosh appearing. Mr. Ghosh mentioning that you take.
He needs some time.
You
On prayer of the petitioner, the matter is adjourned. Petitioners, huh? The matter is adjourned. Paragraph, let the matter appear under the same heading on 12th October.
12th October. My.
Grateful, my lord.
Yes, are we ready with the election petition today?
Election petition, item number
Yes, ready?
Just no, just the next one. Mine is non-election.
Non-election, yes. 3 o'clock election petition is also. I'm sorry.
If
Other matters are released for the day.
it commends your lordship, not only for half a minute. The lordship may recall me, Lord, this is the matter in which Mr. Siddiqui was appearing in connection with the WBIDC matter, where despite there being an order of injunction, there were certain activities which were being done in respect of the land in question. And we had written to them saying that they should take steps because this is in terms of an IBC, my lord, land which has come, my lord. Now, Mr. Siddiqui's junior appeared on the previous occasion.
Item number 6.
6.
Yes, he was supposed to take instructions. I think.
Take instructions and come back. He didn't take instructions on the previous occasion. Matter got adjourned till to today. If you could have given your lordship not the instruction, then we could have gone on with the main matter next. That limited issue of we had written to them and they had written back to us. You first take care and against the run of play, which my lord made your lordship lord really tell them to inquire.
I recall, yes.
Now, my lord,
Will you come back next Thursday?
Come back next Thursday.
And will you please inform?
Yes, I think I'll guide you.
Since I'm not passing an order here, please inform Mr. Siddiqui.
I'll do.
And please request him to take instructions in the meantime.
Yes, we'll do that.
That is necessary.
Could it be there on Thursday week? Thursday week?
Want to come back Thursday week?
Thursday week.
That's 28.
28.
Very good.
29.
28 is a sectional. I hope you no one has a
Kindly let it be Thursday fortnight, not then. Because that is that's a very critically placed day. 28 gives us not 4 days, not back to back. So
why 4 days back to back?
there is a 29th is a holiday.
Is a what? No.
29th is not a holiday. 29th is the water.
28th is a sectional holiday.
So 28th is land. 28th is land. 29th is water. 30th is land. First is land. Second is land.
I got it, sir. No need to.
So a little bit of land in between will make it a continuous stretch.
We'll drown someday.
In Goa.
12th October.
12th October.
On your prayer. On your prayer.
Obliged.
On prayer of the you are the
Petitioner.
On prayer of the petitioners, the matter is adjourned. Let the matter appear under the same heading on 12th October 2023.
The land and the water conundrum. Election petitions, item number 7.
Let us come on to the.
Let us come back. Let us come back.
Because I do not know swimming. So.
Same here, but I like.
But I love water.
Oh, really? We can't swim well though.
Yes. Your witness is there?
Yes, my lord, witness is here.
Will it be concluded today? No. The evidence that we have.
I just hope they had written less.
Evidence that I got. Yes. Oathটা নিয়ে না অনেক দিন হচ্ছে। হ্যাঁ? Yes. The translators are ready? Ready? The last examination was 10th March,
My lord, 16th March is the deposition, my lord, which I see, my lord.
24th. No, 13th.
13th April is there.
Yes.
13th April to my 13th April is 148 booth number.
21C করছিলি তুই।
হ্যাঁ 21C ওই যে এখানে 13th April 13th April বেশি প্রশ্ন হয়নি।
Yes, you were on 21C.
Yes, we were on 21C.
Yes.
The witness is shown PD 15 of the judge's brief of documents. চলে যাও। What is this document?
মেলট আমরা যে অভিযোগ করেছিলাম তার একটা রিপোর্ট।
Who had lodged the alleged complaint?
মেলট পার্টি করেছে।
Can you name any person who had lodged such alleged complaint?
মেলট আমি পার্টিকে জানিয়েছি বা পার্টির পক্ষ থেকে অনেকে ছিল, কে করেছে ঠিক এটা আমার
Who were your polling agents in booth number 148?
মেলট এই মুহূর্তে আমার নাম মনে নেই।
Did you ascertain later, when did you obtain a copy of this alleged complaint? And from whom? কবে এবং কার কাছ থেকে?
নিয়েছিলেন কারো কাছ থেকে? কবে নিয়েছিলেন? কার কাছ থেকে নিয়েছিলেন?
না আমি বলি এই অভিযোগ পত্রটি আপনার হাতে কবে এবং কার কাছ থেকে আসে?
মেলট আমরা পার্টিকে অভিযোগ করেছিলাম, পার্টি কমপ্লেন্ট নির্বাচন কমিশনকে দাখিল করেছিল।
That's not the answer to the question. You want to know the from where you
From
got the copy?
yes, and when?
আপনার হাতে কিভাবে এসেছিল, কার কাছ থেকে?
আমার সেক্রেটারি আমাকে দিয়েছিল।
আপনি প্রশ্নটা বুঝুন ভালো করে, বুঝতে না পারলে আরেকবার জিজ্ঞেস করুন। তারপরে উত্তর দিন। Your witness doesn't come prepared, I'm sorry to say this. I observe it every day. Finds everything new, all, I mean, taken by surprise.
At times I have the same
At
feeling,
least be aware of the petition filed by.
maybe because of the passage of time. The length of the Malad examination and cross-examination
How
this
long is it
period.
be recorded?
I'll tell him, ma'am.
Yes. Yes, next.
When?
নির্বাচনের পরে
Can you give a specific date?
না, এই মুহূর্তে ম্যাডাম মেলাটা মনে নেই আমার।
Was any purported CRPF personnel identified by you regarding this purported complaint?
মিলট সিআরপিএফ এর তো নির্দিষ্ট করে নাম বলা সম্ভব না।
Who had told you about such alleged incident in booth number 148?
মিলট দলীয় কর্মী মহসিন আলী, শাহ আলম বাদশাহ, শাহ আলম বাদশাহ।
Did you personally were you personally present at that booth when such alleged incident took place?
মিলট আমি ঘটার পরে শুনে যাই।
Did any such alleged incident happen in front of you?
মিলট আমি শুনে তারপরে যাই, আমার সামনে ঘটে।
When did you allegedly go to booth number 148? On April 6, 2021?
মিলট ওই 11টার পরে সম্ভবত। পরে শোনার পরে
Possibly, সম্ভবত, possibly. Was such alleged complaint lodged with the Election Commission from your constituency or from any other place?
মিলট আমরা পার্টিকে জানিয়েছি, পার্টি দাখিল করেছে।
Was it lodged from any place within your constituency or beyond your constituency?
আপনার নির্বাচন ক্ষেত্রের মধ্যে থেকে করা হয়েছিল নাকি আপনার নির্বাচন ক্ষেত্রের বাইরে থেকে করা হয়েছিল?
নির্বাচন ক্ষেত্রের বাইরে থেকে।
did the election commission allegedly take any steps based on your purported complaint?
কি আপনার এই অভিযোগের ভিত্তিতে কোনো স্টেপ নিয়েছিলেন, পদক্ষেপ নিয়েছিলেন?
মেলাট নির্বাচন কমিশন লোক যখন আসে তখন অনেকটা সময় পার হয়ে গেছে, এসেছিলেন।
Was any person identified by you with whom the CRPF personnel had allegedly misbehaved or intimidated?
কোনো ব্যক্তিকে কি আপনি চেনেন বা শনাক্ত করতে পারেন যার কে সিআরপিএফ এর জওয়ান যিনি উনি ভয় দেখিয়েছিলেন বা কোনো রকম খারাপ ব্যবহার করেছিলেন? Yes, I can.
Who are these persons?
এই মানুষগুলো কারা?
সাধারণ
Can you name them?
সিরাজ আলী,
Did the said Siraj Ali lodge any purported complaint?
না, পার্টির পক্ষ থেকে আমরা করেছি। আমরা করেছি পার্টির পক্ষ থেকে।
Have you produced any such purported complaint as part of the election petition?
ইলেকশন পিটিশনের পার্ট হিসেবে অংশ হিসেবে এরকম কি কোনো কমপ্লেইন দাখিল করেছেন, অভিযোগপত্র দাখিল করেছেন?
নির্বাচন কমিশনকে পার্টি দাখিল করেছে, আমি ব্যক্তিগতভাবে কিছু দাখিল করিনি।
কোয়েশ্চেনটা একটু বোঝানো লাগে, প্রশ্নটা। না না, এই সিরাজ আলীর কাছ থেকে কোনো অভিযোগপত্র দায়ের করা হয়েছে নির্বাচন কমিশনের কাছে?
সিরাজ আলী আমাদেরকে জানিয়েছে মেলট।
Did the said Siraj Ali inform you personally?
আপনাকে ব্যক্তিগতভাবে জানিয়েছিলেন?
সিরাজ আলী দলের কর্মীদেরও জানায়, পরে আমি উপস্থিত হওয়ার পর মেলট আমাকেও জানায়।
Has any mention been made of the said Siraj Ali in the purported complaint at PD 15?
দাখিল করা হয়েছে তাতে কি নির্দিষ্ট সিরাজ আলী নামক ব্যক্তি উল্লেখ আছে?
না, নেই।
Who did the, so I take it that Siraj Ali's name does not feature in any complaint whatsoever lodged with any authority concerning any purported polling day intimidation.
কি আমি ধরে নিতে পারি যে সিরাজ আলীর নামটা কোনো ডকুমেন্টে উল্লেখ নেই বা কোনো অভিযোগপত্রে উল্লেখ নেই? কোনো ডকুমেন্টে কি সিরাজ আলীর নামটা উল্লেখ আছে? স্যার হ্যাঁ বা না আছে না নেই?
Did you mention the name of Siraj Ali in any complaint lodged by you concerning any purported polling day intimidation at booth number 248? 148.
148
আপনি নিজে যে অভিযোগগুলো করেছেন সেগুলোর কোনটাতে কি সিরাজ আলীর নাম আপনি উল্লেখ করেছিলেন?
How many purported CRPF personnel were present at booth number 148? Who amongst such 10 to 12 personnel were purportedly intimidating or misbehaving with the electorate?
কারা ভয় দেখাচ্ছিলেন বা খারাপ ব্যবহার করছিলেন সাধারণ ভোটার
সিআরপিএফ দের তো এইভাবে নাম বলা সম্ভব নয়। সামনে আসলে দেখানো যেতে পারে।
come in front of me.
Who are the said Sheikh Maisen Ali, MAISEN Ali, and Sheikh Sahalam Badshah, SAHALAM space Badshah, BADSHA, as mentioned in paragraph 21C of your election petition?
See of the election petition. Maisen Ali Sahalam Badshah নামে তার কারা
দলীয় কর্মী।
Were they your polling agents in the booth?
তারা কি আপনার 148 নম্বর বুথে পোলিং এজেন্ট ছিলেন?
না, তারা দলীয় কর্মী।
What were they doing? What were they doing at booth number 148 when they are not polling agents?
48 নম্বর বুথে তারা কি ছিলেন যদি তারা পোলিং এজেন্ট
তারা ওই সময় ভোট দিতে গিয়েছিলেন।
Were they purportedly intimidated or misbehaved with?
তাদেরকে কি ভয় দেখানো হয়েছিল বা খারাপ ব্যবহার করা হয়েছিল?
তাদের সাথেও মিসবিহেভ করা হয়েছে।
Did they lodge any complaint regarding such alleged misbehavior or intimidation with any authority?
অথরিটিকে এই ধরনের ভয় দেখানো বা খারাপ ব্যবহার করা হয়েছিল?
না, আমাকে জানিয়েছে।
When did they inform you?
11টার পরে সম্ভবত।
Did you lodge any complaint on their behalf pertaining to such purported misbehavior or intimidation?
এর সবটাই আমরা পার্টিকে জানিয়েছি, পার্টি অভিযোগ দায়ের করেছে কমিশনকে।
Have they been named in any purported complaint pertaining to any polling day intimidation or misbehavior?
খারাপ ব্যবহার তাদের কোনো ডকুমেন্টে কোনো তথ্যে কি তাদের নামটা উল্লেখ আছে? এই যে মাইসেন আলী শেখ শাহআলম বাদশাহ দেখা হবে তাদের নাম উল্লেখ আছে?
মাইসেন আলী শাহআলম বাদশাহরা এই ঘটনাকে জানিয়েছে, তাদের নাম উল্লেখ আছে।
কি উল্লেখ আছে ওনাদের
হ্যাঁ,
ডকুমেন্টে?
উল্লেখ আছে।
Yes, their name have been.
Can you point out any such complaint where their name has been mentioned?
কোনো একটা অভিযোগ
দেখাতে পারতেন যেখানে তাদের নামটা উল্লেখ করা হয়েছে?
From the documents on record.
কি ডকুমেন্ট রেকর্ডে আছে তাদের মধ্যে কোথাও থেকে আপনি দেখাতে পারবেন তাদের?
So I take it that no complaint pertaining to pertaining to election day alleged misbehavior or intimidation mentions the name of Sheikh Maisen Ali or Sheikh Sahalam Badsha. কোনো অভিযোগ পত্রে তাদের নাম নেই।
তাহলে কি আমি ধরে নিতে পারি যে কোনো অভিযোগ পত্রেই আলম বাদশার নাম উল্লেখ নেই?
না, নেই।
Their names have not been mentioned. Was the said, sorry. Was the said Sheikh Maisen Ali, or did the said Sheikh Maisen Ali and Sheikh Sahalam Badsha cast their votes on for the 2021 assembly elections?
মাইসেন আলী আর শেখ শাহ আলম বাদশা কি এই নির্বাচনে তাদের ভোটটা দিতে পেরেছিলেন?
হ্যাঁ, ভোট দিয়েছেন পরে।
Caste, plural caste. They had cast their votes. They had cast. In paragraph 21C of the election petition, it 21C, 21 go, kokho go. In paragraph 21C of the election petition, it has been alleged that you were informed of some alleged incident at booth number 148 over telephone. Who had purportedly called you?
ঘটনা তার ব্যাপারে আপনাকে ফোনে টেলিফোনে জানানো হয়েছে, কি আপনার
এই মুহূর্তে নাম মনে নেই।
In paragraph 21C of the election petition, it is alleged that you had informed other members of your political party to lodge a formal complaint with the ECI. Who did you instruct?
আপনি বলেছেন যে আপনি আপনার পার্টির কিছু লোকেদের ইনফর্ম করেছিলেন ইলেকশনকে একটা ফর্মাল কমপ্লেন দায়ের করার জন্য। কাদেরকে আপনি ফোন করেছিলেন?
অঞ্চলের যে প্রেসিডেন্ট ছিল তাকে বলেছি।
Who was the president of that area, you say?
বাবলু সাঁতরা।
So I take it that the purported complaint, that is PD 15, was lodged by your election agent or the said Bablu Shatra?
সেটা আপনার ইলেকশন বাবলু সাঁতরার দ্বারা করা হয়েছে, এটা কি আমরা ধরে নিতে পারি?
এই কমপ্লেন্ট, এই অভিযোগপত্রটি
তারা পার্টিকে জানিয়েছে, আমিও পার্টিকে জানিয়েছি, তারাও পার্টিকে জানিয়েছে মেলট।
Who in the party did you inform?
কাকে জানিয়েছিলেন?
পার্টিতে সেই সময় আমাদের রাজ্য সভাপতি, তারপরে আমাদের সাংসদ ডেরেক ওব্রায়ান, এদেরকে জানানো হয়েছিল।
No, and Mr. Derek.
And he is not the.
And our member of parliament, Mr. Derek O'Brien. এবং আমাদের দলীয় সাংসদ মিস্টার ডেরেক ওব্রায়ান, তাই
ঠিক আছে।
Who is the said state president that whom you have supposedly informed?
স্টেট প্রেসিডেন্ট কে, নাম কি তার?
সুব্রত বক্সি এমপি।
So I take it that the purported complaint at PD 15 and the other complaints were not lodged by your election agent or the said Bablu Shatra?
মেলট আমি পার্টিকে জানিয়েছি, বা পার্টি কাকে দিয়ে করিয়েছে এটা তো মেলট এই মুহূর্তে আমার পক্ষে বলার সম্ভব না।
If you can, the question can be explained to him once again. That বা এরা করেননি, তাই তো?
The answer is I cannot say. এরা করেছে কিনা বলতে পারবো না।
মেলট পার্টি কাকে দিয়ে এটা তো আমার পক্ষে বলার
I
সম্ভব না।
cannot say. I cannot say it.
Can you ascertain as to who had made this purported complaint and tell this honorable court on the next occasion?
হ্যাঁ পারবো।
I put it to you. তার আগে, did any common voter make any complaint of any such alleged misbehavior or intimidation?
হ্যাঁ করেছে।
Who are these general voters? Can you name them?
একজনের নাম এই মুহূর্তে মনে আছে, বাকি তো সবার নাম, জেনারেল ভোটারদের নাম মনে রাখার সম্ভব নয়। সিরাজ আলী, যেটা একটু আগে বললাম।
Is there any complaint on record where the said Siraj Ali's name is mentioned?
সিরাজ আলীর নামটা মেনশন করা আছে?
না, নেই।
Did your polling agent or reliever, if any, register any complaint with the presiding officer to such effect? এই মর্মে
মৌখিকভাবে।
did they submit any complaint in writing to any authority even after the elections, even after the polling day pertaining to any such alleged incident?
তারা কি কোনো লিখিত অভিযোগ কাউকে তাকে দিয়েছিলেন নির্বাচনের পরে হলেও?
না, পার্টিকে জানিয়েছে।
Who was the presiding officer in booth number 148?
মিলট এই মুহূর্তে তো প্রিসাইডিং অফিসারের নাম বলা সম্ভব নয়, আমি পরে বলতে পারবো।
পরে বলতে পারবো।
পরে নয়, বাংলার একটু 19-20 হয়ে গেলে বিপদ। What were the said Sheikh Maisen Ali and Sheikh Sahalam Badshah doing in and around booth number 148?
তারা আমাদের দলীয় কর্মী হলে ওই বুথেরই ভোটার।
Our party sponsors, you were the
I put it to you that no such alleged incident took place, and if at all, the election commission had duly resolved all purported issues.
দিচ্ছেন যে এরকম কোনো ঘটনা হয়নি বা যদি ঘটেও থাকে তাহলে ইলেকশন কমিশন সেটাকে পিটিয়ে দেয়।
I put it to you that free and fearless polling had been going on at booth number 148 on April 6, 2021.
না, মানছি না।
The witness is shown paragraph 21D D for Delhi of the election petition. When did such, sorry. Paragraph 21D, page 20. না ছোট। 21D. When did such incident as alleged in the paragraph under reference take place?
যে কথিত ঘটনার কথা বলা হচ্ছে সেটা কখন ঘটেছিল?
সম্ভবত সকাল 10টার পরে।
After 10
Who were the agents of yours as mentioned in paragraph 21D?
যেমন উল্লেখ করা হয়েছে তার কারা আপনার
এজেন্টদের কথা আপনি বলছেন।
মিলট বিজেপির যিনি প্রার্থী ছিলেন তার এজেন্ট।
Did you personally witness any such alleged incident at as mentioned in paragraph 21D?
ডিটেইলস এরকম উল্লেখ করা আছে এরকম কোনো ঘটনা কি আপনি নিজে চাক্ষুষ পর্যবেক্ষণ করেছিলেন?
মিলট আমার সামনে আমি চাক্ষুষ করিনি, আমি পরে গেছি খবর পেয়ে।
can you identify any such CRPF personnel who had purportedly misbehaved or intimidated the voters?
সিআরপিএফ জওয়ানকে শনাক্ত করতে পারবেন যিনি ভোটারদের ভয় দেখিয়েছিলেন বা খারাপ ব্যবহার করেছিলেন?
সামনে থাকলে অবশ্যই পারবে। মিলট একটা ভুল বলেছি, আমার এজেন্টের সাথে মিসবিহেভ করেছে, প্রথম উত্তরটা একটা ভুল দিয়েছি।
Volunteers.
ফার্স্ট উত্তরটা আমার এজেন্টের সাথে মিসবিহেভ করেছে সিআরপিএফ, ওটা আমি কোশ্চেনটা বুঝতে ভুল করেছি। Agent. Misbehave my agent.
I think it's not going, but election agent.
With the party
With the election agent.
Election agent বললেন, আমার election agent বললেন,
হ্যাঁ, ইলেকশন এজেন্ট, ইলেকশন
এটা
এজেন্ট।
কি গেল? Volunteers বলে?
He did not say election agent.
আমার election agentর সাথে misbehave করেছে।
Yes, I also heard that election agent. With my election agent. তার আগে witness volunteers বলে? না witness না volunteer
Who were your agents at that booth?
আপনার এজেন্ট কারা ছিলেন?
মিলট এই মুহূর্তে নাম আমার মনে নেই, তবে নেক্সট ডেট আমি এটা বলতে পারবো, কারণ অনেকগুলো বুথ তো মিলট।
No, because there were so many booths, should not go. Who had informed you of such alleged incident at booth number 61?
ব্যাপারে আপনাকে কে জানিয়েছিলেন?
শেখ আলম আলী আমাদের দলীয় কর্মী। শেখ আলম আলী আমাদের দলীয় কর্মী।
Was any voter prevented from casting his vote at the said booth?
ভোটারকে ভোট দেওয়া থেকে
হ্যাঁ মিলট, বাধা দেওয়া হয়েছে।
Yes is sufficient.
এবং বিজেপি যে প্রার্থী তার পক্ষে ভোট দেওয়ার জন্য প্রভাবিত করা হয়েছে।
who was, can you name any such person who was purportedly prevented or influenced?
কারণ বলতে পারবেন যাকে বাধা দেওয়া হয়েছিল তাকে প্রভাবিত করা হয়েছিল?
এই মুহূর্তে মিলার নাম মনে নেই।
Can you name any such person who had allegedly intimidated or influenced?
কি আরো কারণ নাম বলতে পারবেন যিনি বাধা দিয়েছিলেন বা প্রভাবিত করেছিলেন?
মিলট মেইনলি তো সিআরপিএফ করেছে এটা। তো সামনে থাকলে হয়তো শনাক্ত করতে পারবো।
Who are the said Sheikh Alam Ali and Shumanta Roy as mentioned in paragraph 21D of the election petition?
দলীয় কর্মী।
What were they doing at booth number 61?
মিলট ওই 61 নম্বর বুথের ওরা ভোটার এবং রাজনৈতিক দলের একটা নির্দিষ্ট ডিস্টেন্সের বাইরে যে ক্যাম্প অফিস সেখানেও তাদের থাকার সুযোগ আছে।
I put it to you that Who had lodged such purported complaint?
অভিযোগ কে
পার্টি দায়ের করেছিলাম।
Who in the party had lodged such purported complaint?
এতে কে এই ধরনের অভিযোগ দায়ের করেছিল?
কোন ব্যক্তি আর কি?
মিলট আমরা তো পার্টিকে জানিয়েছি, এবার পার্টি কাকে দিয়ে এটা করিয়েছে এটা তো আমার পক্ষে এই মুহূর্তে বলা সম্ভব না।
I don't know.
I do not know.
Has any person been named in such purported complaint at PD 16?
যে কমপ্লেন অভিযোগটা দায়ের করা হয়েছে তাতে কি কোনো ব্যক্তির নাম উল্লেখ আছে?
মিলট আমাকে তাহলে দেখে বলতে হবে, এই মুহূর্তে আমি বলতে।
PD16 ওনার হাতে আছে।
দেখে বলুন।
It's a matter of record.
Or
He
I
says
put it
yes
to
or
you,
no.
I put it to you, question, I'll rephrase the question. I put it to you that no person has been named in such alleged complaint at PD 16.
কিনে যে অভিযোগটা দায়ের করেছে এখানে কোনো ব্যক্তির নাম উল্লেখ
না আমি মিলট দেখতে পাচ্ছি না।
আছে কি নেই? হ্যাঁ বা না?
I agree.
না এখানে কিছু নাম নেই।
I agree. How many CRPF personnel were stationed at booth number 61?
61 কতজন সিআরপিএফ পার্সোনাল জওয়ান ছিলেন?
এই মুহূর্তে তো সংখ্যাটা বলা সম্ভব না। সিআরপিএফ জওয়ান প্রত্যেকটা বুথে ছিলেন গোঘাটে।
Did your polling agents report any such alleged incident to the presiding officer?
মৌখিকভাবে জানিয়েছি মিলট।
Who was presiding officer at booth number 61?
মিলট এই মুহূর্তে আমার নাম জানা নেই।
Did your polling agents report any such, make any purported complaint even after the polling day in writing? লিখিতভাবে অভিযোগ করেছেন নির্বাচনের দিনের পরে?
আমরা জানিয়েছি পার্টিকে,
Polling
এজেন্ট কিছু করেনি।
No.
Polling agent. No. Did your polling agents inform any such alleged incident to the highest ranking officer of CRPF at that booth?
সর্বোচ্চ পদাধিকারী কোন সিআরপিএফ এর কোন ব্যক্তিকে কি জানিয়েছিলেন? Yes, they have complained.
To whom was such complaint lodged?
কার কাছে করা হয়েছিল?
মিলট সিআরপিএফ জওয়ানদের তো এইভাবে নাম বলা সম্ভব না।
Who had made such alleged complaint?
এই ধরনের অভিযোগটা করেছিল?
মিলট পার্টির পক্ষ থেকে আমার যারা দলীয় কর্মীরা ছিল তারাও করেছে, আমার পোলিং এজেন্টও করেছে। পরে আমি গেছি, আমিও করেছি।
as well as the of the party was such complaint.
You had asked about written complaint, isn't it? লিখিত অভিযোগ করেছিলেন?
না, লিখিত অভিযোগ কিছু করে।
লিখিত অভিযোগের কথা জিজ্ঞেস করছেন।
How many voters were allegedly misbehaved with or intimidated at booth number 61?
ভয় দেখানো হয়েছিল বা বাধা দেওয়া হয়েছিল, খারাপ ব্যবহার করেছিল।
সংখ্যাটা অনেক হবে, কারণ সকাল থেকে চলছিল। সকাল থেকে চলছিল।
I put it to you that your complaint is false, baseless, and fabricated.
অভিযোগ ভিত্তিহীন এবং বানানো।
সত্যি মানছি না।
I put it to you that free and fearless poll was ongoing at booth number 61 from the inception.
এবং ভয়হীন প্রক্রিয়া বুথ নাম্বার 61 শুরু থেকে। আপনি মানেন না মানেন না?
মানছি না, কারণ 10টা 17তে আমরা অভিযোগ করেছি, 12টার পরে অ্যাকশন নেওয়া হয়েছে।
I disagree. I put it to you that your purported complaint is unsubstantiated and as such could not have been lodged. I disagree হবে, is unsubstantiated and could not have been lodged.
ভিত্তিহীন।
ভিত্তিহীন কোনো প্রমাণ নেই।
না, ভিত্তিহীন না, সত্যি
I disagree.
মানছি না।
Stop next.
এই ওর কোন ডেট সুবিধা হবে?
PW1 is further cross-examined and cross-examined in part and discharged. Paragraph. On prayer of learned counsel for the respondent, the matter is adjourned. Paragraph, let the matter appear under the same heading for further cross-examination of PW1.
Should it be on my prayer, my lord, or
Yes,
should it be on my prayer or generally, my lord?
you want a general?
Generally, my lord.
The matter is adjourned. On prayer টা কেটে দিন। লিখলাম না, on prayer of the ওটা কেটে দিন, the matter is adjourned. Let the matter appear under the same heading, ওটা থাকবে for further cross-examination of
Any data is
PW1
free,
on
next.
when can you come back? 28th
28th,
is a
okay,
sectional holiday, no difficulty.
let's try.
Otherwise 5th. Otherwise 5th of October.
He's all right with 28th of September.
Wait, let's try for 28th or let's, my lord, keeps it on the 5th, better. We
Yes.
don't know, my lord. Last moment, what happens?
Very good.
ওনার প্রবলেম
মানে ওই ultimately একটা বার resolution কিছু একটা নেবে।
বুঝতে হবে না।
But we still don't know, my lord, what last moment, what happens on 28th.
What will happen on the last moment? It's a sectional holiday, that's all.
Manifest.
So again, that water and again, that land and water problem. Yes.
Will ensure that
I'm not.
5th of
My lord, the witness seems to have some problem on 5th.
ওর আগে
Then
বুধবার বা শুক্রবার।
the next is
No, my
12th.
lord, I think takes up matters only on Thursday's original
So it
side.
will be 12th. then.
12th October. My lord, he's all right with 5th.
5th হবে?
Yes.
5th October.
5 তারিখ হবে আপনার? 5 তারিখ তাহলে? হ্যাঁ, নাহলে
5th
আবার
October,
পিছিয়ে
my
যাবে।
lord.
Grateful, my lord.
Grateful, my lord.
3 PM.
3 PM.
Three PM.
Mark
Great.
it 3 PM. It's at your table again.